One case submission matter. I have filed an application for amendment and your lordship directed for amending that rate application, incorporating that annex of. I have already filed. So let that be there.
May I please use? The management, that is TP Tata Power, they have filed rate appeal in the year 2017. Now that appeal is yet to be admitted. Now the version of the registry is that once there is a continuation of delay, so the matter will be under the heading of after notice. My plea is that since appeal is not yet admitted, let it be district before resolution.
Pardon to mention, this press CMAPA for recalling the order passed in a review petition. The council arguing at that time had wrongly submitted that there were no instructions. So kindly.
Yeah, pardon my lord. One extension of time, my lord.
Yes.
Well, may I beg your pardon, your lordship, to make a mention, your lordship. My lord, JCRLA 41 of 2019 and JCRLA 47 of 2019, my lord. In both the cases, the petitioners are custody for more than 8 years in one and another in more than 10 years, your lordship. I have filed 2 IA for bail, your lordship.
All right. Give the memo.
I am handing over.
Give the memo.
I am handing over the memo. Obliged.
Supplemental list, item number 1.
Item 126, therefore, adjournment for after that.
This is relating to the matter where AS order has been challenged. The lordship was disposed of 8247/2025 to adjust the all remedies.
Madam, in view of the Honorable Supreme Court's order, you are to seek the appropriate remedy. So, AS order cannot be challenged here unless you exhaust the remedy. So, this order is very detailed one. A number of writ petitions we have disposed of, so we are passing this order. You are to avail the alternative remedy as has been observed in that case 15A, 12B, and the Honorable Supreme Court has stated that in each case, first we have to see that whether the petitioner has availed the this remedy or not. So once you exhaust this remedy, then writ petition will be maintainable. So in late later they keep further, entire disposal. Next.
Item 4.
I please your lordship. I am appearing through virtual court Kalahandi. Your lordship, here in this writ application, I have prayed for the direction to the opposite parties to sanction and disburse the compensation in pursuant to the judgment passed by the learned senior civil judge LR and LTV Bhavani Patna in LAR case number 6 of 2020, your lordship. Your lordship, so here.
You are the executing court or what?
Yeah.
If the award is in your favor and they are not paying the amount, why have you come here?
Your lordship, I invoke the jurisdiction of this honorable court because I have specifically mentioned in para 7 of page 6. Your lordship, in this case, the OP cannot be said to have violated the order, especially when there is no time limit is specified. There is no time limit specified in the judgment. Second is, the reference is made to Annexure 3, wherein this honorable court had been pleased to pass the order in the similar cases. Most importantly, when there is no time limit has been fixed, they are simply saying that the order is at the stage of administrative approval.
The law is that even if the time limit is not fixed, then what is to be done? What should be the reasonable period? It's not that the person against whom the order has been passed to pay, he will just sit or take that ground and file. Why? We will execute the order passed by the civil judge senior division. It has already been held that you are entitled to get the higher compensation
Yes,
for the
yes,
acquired land at this rate, and what would be the
page number 22, Your Lordship.
everything has been in your favor.
Yes,
This
yes,
order
Your
was
Lordship.
passed on 12/8/2024.
Yes, Your Lordship. And to my knowledge, the opinion opinion from the government has already been submitted, and calculation has already been sent to the higher authority for approval.
This is basically a decree.
No, you have to
Yes.
execute that. File the execution process. Listen, this writ petition has been filed. For a direction to the opposite parties to sanction and disburse the compensation amount which the petitioners are entitled to in view of the judgment dated 12/8/2024 passed by the London Senior Civil Judge LR and LTV bracket ends, Bhavani Patna, Kalahandi. In LAR case number 6 of 2020 within a stipulated period. The London Council for the petitioner submitted that even though there was a specific direction by the London Civil Judge, Senior Division LRTV, Bhavani Patna, to disburse the compensation amount by enhancing the same, and though in the meantime more than 8 months have passed, but the petitioners have not been paid the decree amount stuff. Since alternative remedy for executing the decree is available with the petitioner, which they have not resorted to, it is open to the petitioner to seek an appropriate remedy in accordance with law. Accordingly, the petition is disposed of. You are Mr. Akash Kumar Porjoshi.
Yes, yes, Your Lordship.
Akash Kumar Porjoshi, London Council, appearing through virtual High Court. It is from Kalahandi, Bhavani Patna. All right.
Much obliged, Your Lordship.
Item 5.
My lord, in this matter, we are the caveat.
Yes,
We are the caveat in this matter. We have filed a caveat.
have you solved a
Self-service.
uh,
By Monday, I'm sorry, Rasit, make all this version after back.
okay.
No, but
Mr. Puspala Land Council submits that since in this a caveat petition filed, in this writ petition, a caveat petition filed, you will serve the copy of the writ petition on the Land Council for the caveat during course of this week
Monday, by Monday, I'm sorry.
by Monday. By Monday, मैंने date लिखी है तो by 5th of May,
Mira.
5th of May 2025, list this matter in the week commencing from 12th of May 2025 for admission. After vacation. As prayed for after vacation.
Item 6.
We are for the Union of India. Madam.
Yes, Mr. Union of India, yes, it is there, but have you not received a copy of the writ petition?
And we are the petitioner. Sorry, sir. Sorry, sir.
No, it is,
Item 6.
Opposite party, yes. We are
taking a fight. Yeah, next. Well,
Item 6.
Yes. Just I am giving the petition copy to the
On behalf of
Commissioner Department.
Kendra,
KBS.
just now he has served answer that copy, my lord.
caveat petition का कहीं आधे attach ही नहीं?
No caveat.
Just
Read
have the copy
the
of-
copy.
So you have instruction to appear for the opposite party or what?
Yes, and my name, I will file counter and 2 extra copy will serve after that.
Madam.
Obliged.
So when have you filed your wakalatnama?
No, in course of time.
Huh?
No, not fine. Not fine.
So when you will file the wakalatnama? If
Not
you have
fine.
instruction to appear for opposite party, then
Within-
you have to when you will file wakalatnama?
Within 1 week. Within 1 week, I
All right. Kendriya Vidyalaya Sangathan. Consul and council appearing for the Sabuda for all the parties submits that he has instruction to appear for all the opposite parties, and you will file a wakalatnama by the date next week. By next week, stop. The Land and Council for the petitioner handed over a copy of the writ petition to the Land and Council for the opposite party. For all the opposite party. And he seeks time to obtain instruction out of this matter after summer vacation. ଆପଣ ଆଗେ ଓକାଲତନାମା ମ୍ୟାଟର ଯଦି ନୋଟିସ ଇସ୍ୟୁ ହବ ତାହେଲେ ଫର୍ମାଲି ନେଇଯାଇ
Item 7.
Item 7, the United petitioner. It is a case of SCP, MSCP. The similar nature of case has already been fixed to 5th. If lordship will fix it, all the matter can be heard together.
Similar matter has been
5th. It was fixed to 5th. Other councils are there. It was fixed to 5th of this month. Yeah, May. 5th of May.
Can you give the number so that it will be tagged to that?
My lord, I will pass on, my lord.
All right. Mr. Pari, Land Council submits that WPC number so and so, which is fixed to 5th of May 2025, is analogous to this writ petition, and therefore this matter may be listed on 5th of May 2025 along with the said so and so. They will list this matter along with so and so.
I will pass on.
Okay.
Item 8.
Yes.
Item 8 on behalf of Digambar City. A similar matter was disposed of 23/25. This is
Come this side.
They put question might touch it to him.
This similar matter was disposed of 23/25. This is the download complaint.
Three.
Oh.
3G5. এটা ন্যাশনাল হাইওয়ে ম্যাটার
এটা হচ্ছে ল্যান্ড অ্যাপ্লিকেশন
नहीं नेशनल हाईवे अथॉरिटी अपवर्ड करते हैं तो लैंड अगेन नेशनल हाईवे देखिए जहाँ करेक्शन कर रहा था कर दो या डिस्पोज से 3G5 रे arbitrator को move करिवे provision is there if they are dissatisfied with the amount so 3G5 रे ये करिवे एवं arbitrator decide कला परे appeal लाई करिवा section 34 रे arbitration conciliation act only like district judge. Yeah.
Item 9.
Landing question, advocate position. Landing question was acquired in the year 1980. Advocate position is the landing question part of the land out of 31 district was acquired in terms of earlier Land Acquisition Act 1894 as back as 1984. The recorded owner then, Surama Devi, she has also Surama Naik, recorded as Devi. She has also received compensation. That documents are available on record. What she did is, after receiving compensation, she has alienated 36 disposal of property in favor of one Uday Maji. Then Uday Maji in this one has alienated the property to my client's law. Property
without knowing these facts, fruit recorded, permission granted, all these things there. But position of law remains 2012 Supreme Court that after 4-1 notification, any transaction is not binding on the state. That's the position of law. But today fact remains that out of 36, only 5 decibels have got recorded in my name as a purchaser because 31 decibel have been acquired. Rest 5 have been recorded. Only position is in terms of the new law and old law. That property is not utilized by the state in any manner whatsoever, it's still lying under my possession. If the state would like to recall property to me on receipt of money, whatever the state will decide, or will denotify, denotification is also not permissible. Once it's vested, it's not permissible.
101 new act.
If at all they can reconvey it, because they are not using it for the purpose, it was new law says, if a lordship sees new act, that says that if it is not used, then they are to restore it back. New law attack.
New law 101. Old law 48.
Old law 48, new law, see section 93.
101.
101.
The card is Sakale. Very little.
Corona 18, 48.
101, lordship is granted. 101, yes. Return of unit price. 93 is withdrawal of notification.
There can't be a direction to that.
But again, your space is there the restriction here. 101 also says property acquired under this act means 2013 act. Our land is acquired in 1894 act. 101 is also
Section 48.
48
Denotification.
After it's vested in the state, withdrawal is not permissible. 2012, volume 12 SEC, page 133.
Yes.
After property stood vested in the state even has no jurisdiction to denotify it because it stood vested from.
Stood vested.
Only thing is if they will reconvey, having on a consideration that it is not being used for the corporate return, lest any person encroach upon the property or I am still in occupation, I will pay the value of the land to the state only to that extent if they can obtain instruction and come back to your election.
No, you have not proceeded against that person. It is virtually cheating you.
No, not say tribe.
Because after he has.
I am a second purchaser even. She has sold to a Sidhu tribe. Then that Sidhu tribe took permission and sold it to me. When I applied for.
What is your status?
Beg pardon?
What is your status? For the land?
Status is lying vacant as it is.
No, what is your status? For the land? Are you a owner? Are you what are you?
I am in fact.
How do you describe yourself?
Raising a claim on the basis of a document which is not binding on the state. The other say void document. In that case, there is
The
law.
document itself cannot entitle you to claim anything because by the time this document was executed by your vendor,
It is backward. Payment
Completely
is
void.
not one
Completely
law
void,
is there.
sir.
One law is there. But if your lordship will consider that it's a void deed, then my possession from that day beyond after 30 years will become adverse.
All these things not
Secretary suit to judge. But I am not joining issue there. I only seek equitable relief. If the state can obtain instruction to reconvey me back the property,
That executive can do.
Beg pardon?
That executive can do. You can't approach them.
File representation that can be
If they
considered.
can come back with the instruction on this, we'll pay the
No,
consideration.
entertaining this writ petition would be.
Pandora's box.
Again?
Opening Pandora's box.
We'll reconvey. We'll purchase the
You
property.
convey them. You.
The
Give representation.
petitioner, Kavita Giri, has filed this writ petition for a direction to the opposite party to take steps for withdraw from the acquisition the extent of acres from 31 decimal and direct the same to be recorded in favor of the petitioner. though Mr. Rathal and senior advocate argued that the provision under section 101 of the 2013 Act.
He can find a suit.
Ma'am, is applicable in the case in hand for return of the unutilized land. However, think that we will avail the appropriate remedy in accordance with law, which is permission to withdraw this land according to this course of withdrawal. This is all a clause without.
See, now the regime is changed. The adverse possession, you could have used as a seal only, not as a sword. Now the regime has changed.
Yes.
You can use it as sword as well as seal.
Sure, I just
Then-
wanted to know what your lordship observed. I could not hear.
We said that you can avail the appropriate remedy. You are claiming that should be returned to you in view of the provision under section.
That observation.
So and so that we have stated that.
They
Yes.
spoke instead of dismissal, lordship.
No, we are not disputing.
I could not in fact hear it. That's
No,
the-
no, it's-
I'm sorry.
Yes.
Item 10.
Around for the petition. Similar matter has been disposed of by the Honorable Court on the copy of the order.
That's not high.
The remedy अच्छी से Yes.
Item 11.
My lord, in item 10, my lord, I'm sorry. My lord, item 10, my lord, I'm representing Union of India. Let them serve a copy, my lord.
Copy हुआ dispose of ହେଲା से common order कर दे हम नाटा खाली reflect कर दो तो
My lord, my lord, S.K. Sahoo DSC,
ଆପଣ list ଦେଇନାହାନ୍ତି list ତ ଦିଆଯାଏ ନା ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆର ଗୋଟେ ଲିଷ୍ଟ ଦିଆଯାଏ କାହାର କୋଉଥିରେ ନାଁ ରହିବ
ଆଜ୍ଞା ଲିଷ୍ଟ ଦିଆ ହେଇଯାଇଛି
ଠିକ ଅଛି ତାହେଲେ ସେ ଅନୁଯାୟୀ ରହିବ ଆଉ କଣ
ଆଜ୍ଞା
ୟେସ୍
obliged.
Item 11.
The last occasion I got that the instruction of the state. I pay some more time to sending the letter, but we are not received the instruction letter.
ଅନୁଯାୟୀ objection hearing କରିବାର provision ଅଛି
Have you got the instructions?
No, we are not received.
Not got the instructions.
hearing of objection any person interested in notification of being recorded within 60 days from the transferring notification every objection and shall be made to the collector. Collector shall give the objector an opportunity of being heard. The land council for the state seeks some further time to obtain instruction as per the order dated 9/4/2025. Raise this matter after summer vacation.
Item 12.
Letter regarding rejection of the.
You have to produce the certified.
Yes, sir. Certified copy.
Have you given a copy?
Yes, sir.
What is this read for?
Rejection of my application under section 28A. Thereafter, the annexure 6 is there. Height of
Similar order.
22/3/2025.
Therefore, similar order also.
The rejection order of annexure 5 is the internal communication with the of the advertisement and the and thereafter the annexure 6 is there. If,
This reference case re kon apon thile? You are the
No, madam. I have filed an application under section 28A of the Land Action 1894.
yes.
Referring the said judgment, that is same notification and same village, the judgment passed by the learned referral court, the senior civil judge. My application, 28 application should be considered on that, on the basis of that judgment. Your Worship.
You are challenging the order dated 4/4/24.
24, Your Worship.
Of the land of the Special Land Acquisition Officer, Lower Indra Irrigation Project, in which the petition filed so was rejected.
Madam.
On point reject hela?
On page 25, last paragraph, letters. The estimate in the referred case, LR case number 183 of 2010, filed by the Putten Maji, wife of late Gorosa Maji and others, under section 18(1) of the Land Action Act 1994, has been submitted for kindly sanction to the Department of Water Resources via this official letter number such and such. The same has not been sanctioned till then. Since its sanction in referral LR case number 183 of 2010 has not been accorded, the petition under section 28 of the Land Action Act cannot be disposed of at the present.
So, what on sanction helani na?
There are another six. Your Lordship also disposed of page 27, that is annexure 6. Look at another 8 numbers of recap.
And once you file another 28 application, that would be time bar. It is to be required to be filed within 3 months, no?
3 months.
So we set aside the order now to fresh considerations. Once you filed whether it was rejected and process either these have been sanctioned, we set aside the order. Freshly adjudicated the matter in accordance with laws in a 3 months. See.
Yes.
Change कर दे लेनी.
Annexure 5 them 4/4/2024.
अरे आई चेंज काय कर
गोल बोलेगी चेंज कर लेनी. Annexure तादेरे जो येटा ही चीज़ है तो annexure 6 थिला जो sanction order.
Annexure 6.
आदेरे
अरे जो necessary changes करो तो ना गुड़ा सो ये गुड़ा चेंज कर दे दियो तो. We will also cross check, but till you do it.
এটা হচ্ছে 20/3/2025 annexure 6. ଏଟା ହଉଛି କଣ ଗୋଟେ ବୁଲ ଲେଟ କରିଦେଲା ପଡିଛି ତେଣୁ ଆମାଉଣ୍ଟ ବି ଅଲଗା ହେଇଥିବ ତେଣୁ ସେଗୁଡାକ ଗୋଲ ବୁଲେଇକି ଚେଞ୍ଜ କରିଦେଇ ଦେଇ ଦିଅନ୍ତୁ ହେଲା ଇନକ୍ଲୁଡିଂ କେସ୍ ନମ୍ବର ବୁଝିଲେ ସବୁଗୁଡା ପେନସିଲରେ ଗୋଲ ବୁଲେଇ ଦେଇ ଦିଅନ୍ତୁ ୟେସ୍ ଏଇଟା ଲେଖିବେ ଲ୍ୟାଣ୍ଡ କାଉନସିଲ ଫର ଦି ପିଟିସନର as per the order dated so files the certified copy of the judgment passed by the Learned Senior Civil Judge Nuapada in LAR number 183 of 2010, which is taken on record. After you order to correction dispose of.
Item 13.
Proceed.
Yes. The petitioner is challenging the inaction of the opposite party's member. The royalty land of the petitioner taken by the opposite party and used construction of Harihar Bridge Murthamdi without any noticement. Your Lordship, may I kindly say Annexure 1 ROR. This is the royalty land of the petitioner. And the petitioner is a scheduled tribe, poor person.
You have not been paid compensation.
Nothing, my lord, till that. Your Lordship, may kindly
It's
say.
all right, you have filed a representation, we are going to that. Where is the material that this particular land of yours has been acquired for this purpose? ଆପଣ କହୁଛନ୍ତି ଯେ ମୋର ଜମି ଆକ୍ୱାୟାର କରାଗଲା ଏବଂ ମୁଁ କୌଣସି କମ୍ପେନସେସନ ପାଇନି, ଏଇଆ ତ?
Yes.
ଏଇ ଜମିଟା ଆକ୍ୱାୟାର ହେଇଛି ବୋଲି ନୋଟିଫିକେସନ କାହିଁ ଯୋଉଥିରୁ ଜଣା ପଡିବ ଯେ ଆପଣଙ୍କ ଜମି ଆକ୍ୱାୟାର ହେଇଛି ବୋଲି?
ମତେ କିଛି ନୋଟିସ ଦେଇନି, ନୋଟିଫିକେସନ ଲ୍ୟାଣ୍ଡ ଏକ୍ୱାର୍ଡ ହେଇନି। ବ୍ରିଜ କମ୍ପାନୀ ହେଲା ଆମ ଏରିଆରେ ବ୍ରିଜ କନଷ୍ଟ୍ରକ୍ସନ କରି ମୋ ଜମି ଉପରେ ରୋଡ କରି କରିଦେଲେ। ମୁଁ ଯାଇଥିଲି
କେବେ?
2018-19।
2018 ହେଲାଣି, ଆପଣ ଜମି ଉପରେ ଗୋଟେ ବ୍ରିଜ ନେଇଗଲେ, ଆପଣ ଚୁପଚାପ ରହିଗଲେ?
ବିନା ନୋଟିସରେ ନାଇଁ, ମୁଁ ଚୁପଚାପ ରହିନି, ମୁଁ ଯାଇକି ଅବଜେକ୍ସନ
नहीं आपण मार्च 2025 रे ही रिप्रेजेंटेशन ଦେଇଛନ୍ତି, ତା ଆଗରୁ ତ କିଛି କରିନାହାନ୍ତି।
ଏ ଯୋଉ ଆନେକ୍ସର 6 ଟା ହଉଛି ଯୋଉଟା ରିପ୍ରେଜେଣ୍ଟେସନ, ଏଟା ହଉଛି ମାର୍ଚ୍ଚ 2025 2018 ମସିହାରୁ ଆପଣଙ୍କ ଜମି ଉପରେ।
Your Lordship, may kindly see Annexure 3, man. The collector and district magistrate received on 3/10/2024 and the superintending engineer received the representation, my lord.
ଜମି ଅଧିକରଣ ହୁଏ ସେତେବେଳେ ଯୋଉ ପ୍ରୋସିଡ୍ୟୁର ଫଲୋ ହୁଏ, ନୋଟିସ लेकिन କୋଉ ଜମି ଗୁଡାକ ତାର ପ୍ଲଟ ନମ୍ବର କେତେ, ଖାତା ନମ୍ବର କେତେ, ସେଗୁଡା ସବୁ ବାହାରେ। ତ ଆପଣଙ୍କ ଏଇଟା କଣ ଦେଖି ନାହାନ୍ତି ନା କଣ ଜାଣି ନାହାନ୍ତି? କାରଣ ଅନ୍ୟମାନେ ସେ ଏରିଆର ସମସ୍ତେ ତାଙ୍କର ଜମି ଯାଇଥିବ, ସେମାନେ କମ୍ପେନସେସନ ପାଇଥିବେ, ଆପଣ କେମିତି ଜାଣିପାରିଲେନି?
ଆପଣଙ୍କ ନାଁରେ ଲ୍ୟାଣ୍ଡ ଥିଲା ନା ଆଉ କାହା ନାଁରେ ଲ୍ୟାଣ୍ଡ ଥିଲା? କମ୍ପେନସେସନ ଯାର ନାଁରେ ଥିବ ତାକୁ ଦିଆ ହେଇଥିବ।
ହଁ, ନାଇଁ, your lordship, may kindly say Annexure 1 ROR. This is my plot. And ମୁଁ FIR ବି ଦେଲି, ମୁଁ ଯାଇକି ଯେତେବେଳେ ଅବଜେକ୍ସନ କଲି, ମତେ ଠିକାଦାର ଯେତେବେଳେ ଗାଲି କଲା, ମାରପିଟ କଲା, ମୁଁ FIR ବି ଦେଇଛି, ଏଇଟା ମୁଁ ପଢି ଦଉଛି ଭାଇ FIR।
ନାଇଁ ନାଇଁ, ଠିକ ଅଛି, ଆପଣ ଗାଳି ଦେଲେ, ଯାହା କଲେ ସିଏ ଏତଲା ସେ ବୁଝିବ ସେ।
Yes, your lordship, at last, may kindly say
we just want to know that where is the documentary proof that this particular land of yours which you have mentioned in the representation has been prepared for this particular purpose, construction of Hariharjo bridge,
Mursundi village. Your lordship, may kindly see page 20 Annexure 3.
এই তো রিপ্রেজেন্টেশন খালি, ଆଉ রিপ্রেজেন্টেশন ଛଡା ଆଉ କିଛି
ୟୁନିଲେଟରାଲ ରିପ୍ରେଜେଣ୍ଟେସନ ଆପଣ ଦେଇ ଚାଲିଛନ୍ତି 2019 ରୁ 2025 ଯାଏଁ।
ଦେବି, my lord. Your lordship, may kindly see Annexure 5 ନିର୍ବାହୀ କାର୍ଯ୍ୟାଳୟ ପୂର୍ତ୍ତି ବିଭାଗ, ରାସ୍ତା ଓ କୋଠା, ବୀରମହାରାଜପୁର, my lord, ଶଶିଭୂଷଣ ଭୋଇ, ମୁର୍ଶୁଣ୍ଡି, କ୍ଷତିପୂର୍ତ୍ତି ମୂଲ୍ୟାୟନ।
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ, ସେଇ ଜମି ଆକ୍ୱାର ହେଇଛି କି ନାହିଁ, ଜମିଟା ତାଙ୍କର ଅଛି ବୋଲି ଜଣା ପଡୁଛି ROR। ବଟ୍ କ୍ୱେଶ୍ଚିନ୍ ଇଜ ଦ୍ୟାଟ୍ ୱେଦର ଏଇ ଜମିଟା ଆକ୍ୱାର ହେଇଛି କି ନାହିଁ, ଆଉ ଦ୍ୱିତୀୟ ଜିନିଷ କମ୍ପେନସେସନ ପେମେଣ୍ଟ ହେଇଛି କି ନାହିଁ। ତାପରେ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ, ତାପରେ ରିପ୍ରେଜେଣ୍ଟେସନ, ନହେଲେ ରିପ୍ରେଜେଣ୍ଟେସନ ଖାଲି ଡିସ୍ପୋଜ ଅଫ୍ କରିଲେ ସେଠି ପୁଣି ଯାଇ ଧାରଣା ଧରି ବସିଯିବେ। The petition has been filed by the petitioner Shashibhushan Bhoi with a prayer for a direction to the opposite parties to pay land compensation for the acquisition of the land appertaining to Khata number 550, plot numbers 3780 and 3781, area acre 1.53 decimal in Moja, Mursundi, Tahsil, Maharajpur in the district of Suvarnapur. Though from the annexure 1, the ROR, it indicates that the aforesaid land stands recorded in the name of the petitioner, but the Land Council for the petitioner has not filed any document that such lands have been acquired for the purpose of construction of Hari Harjure Bridge, Musundi. The Planning Council for the petitioner further submits that though the petitioner is filing repeated representation before the collector Suvarnapur for payment of compensation, but that has not yielded any fruitful result. Let the Land Council for the obtain instruction as to whether the aforesaid land has been acquired for the construction of so and so, and if so, whether any compensation amount has been paid or not. Put up this matter after summer vacation.
Your Lordship, Annexure 5 टिके मेंशन कर देबे कि मते नोटिस करी जंते से कंपनसेशन पा Annexure 5 2025 रे ताकू नोटिस करी जंते जे तोमर केते हेबो हिसाब करबा सबली सप्लेटर ऑफिस को डका हिची
ताकू
मते ससुशन लेना Annexure 5 रे
Annexure 5 एटार किसी जमी फमी ना किसी देई ना
यस
এই জমি পাই বলি কোড কে তো লেখাইনি আপনাদের
নাই
ও অন্য জমি পাই এই
কিন্তু মতে এটা নোটিস করে সেটা সেমতি কাম
গলেনি কোন কোন হলা অসুবিধা কোন হলা ଆପଣ ଯଦି ଜମି ଇଏ ହେଇଛି ଆଣିକିନି କମ୍ପେନସେସନ ରିସିଭ କରିବା ପାଇଁ ମୂଲ୍ୟାୟନ ପାଇଁ ଡାକିଲେ ଡକୁମେଣ୍ଟ ଧରିକିନି ତ 7/1/2025 ରେ ଗଲେନି କାହିଁକି
ମୁଁ ଯାଇ କହିଲି ସେମାନେ ମତେ କହିଲେ କେତେ ହେବା ତୁମ ଜମି କଣ କହିଲେ ଆଉ ତାପରେ ସେଇଦିନ ପଳେଇ ଆସିଲା ଆଉ କିଛି କହିଲେ
ଆଡ୍ କରିଦିଅନ୍ତୁ ହି ଫର୍ଦର that the petitioner also received a notice from किए दिला ये नोटिस आपको
इटा दिल्ली मते आगे सहायक बाहिर जंत्री बिरमाहात को
ये सिर्फ माने अपोजिट पार्टी केते ये
अपोजिट पार्टी नंबर महिला 8
असिस्टेंट इंजीनियर कमा रोड एंड बिल्डिंग बीर महाराजपुर अपोजिट पार्टी नंबर 8 and he appeared before the concerned authority, but in spite of that he has not been paid in concession amount of the instruction level. Yes.
Please get that in.
Next.
Item 14.
Your password.
Summer vacation.
Item
Password. Next.
Item 15.
15, Mr. Namtua. Password.
Item 16.
May I please? Fine. I listed for today for consideration one. In the last occasion, I filed an I seeking some correction in the prayer portion. In advertisement, I have made 3 wrongs in the prayer. That's why I find this and short copy on my own.
Get out. So, it's a formal prayer.
My lord, we have no objection.
IN number so and so, this is an application for amendment of the prayer portion of the writ petition. Land Council for the Union of India has received the copy of the interim application and fairly submits that he has no objection for such amendment. So, after hearing the Land Council for the respective parties and going through the amendments taken in the interim application, prayer is allowed. The council for the, have you filed a consolidated?
I will consider only to replace that page only, my lord.
Prayer portion. prayer portion টা
Page only, my lord, page 12.
page সেটা 12
Bar.
bar আচ্ছা submit that he may be permitted to replace only page number 12. Permission is granted. Copy of the same. Page number 12 be handed over to the Land Council for the Union of India. Police, the matter, let it come next week.
Oblige.
Yes. I এটা dispose of করে দেখিয়ে দেবে, হ্যাঁ?
Item 17.
Yes, Mr. Mishra.
My lord, petitioner husband filed an application before the Tahsildar Begunia, so he is a landless person. In the 2015, thereafter, my lord, all the verification was made, so we come to page number 19, and Tahsildar, after the proper verification, the scheduled land, khata number 227, plot number 109 and 4 decimal is confirmed and direct to order in the name of the husband and wife, husband Chandrasekhar and present petitioner. In the meantime, my lord, the petitioner, the Chandrasekhar, was in cancer patient, and in 2019, he had died in the COVID period. Is past, my lord. After the death of the husband of the petitioner, he is enabled of no contact with the office, my lord. In the meantime, further confirmation, the Tahsildar Begunia sent for the confirmation of the office of the sub-collector. But sub-collector, without giving any reason, my lord, annexer, page number 28, and I reject the there of the petitioner, my lord. Thereafter, in 24, he applied the petitioner before the collector, but collector reject that the time limit is over. Page number, my lord, annex 8, page number 31.
So what is the wrong in it? The period prescribed is 90 days.
Yes, ma'am.
And if it is filed beyond 90 days,
Yes, ma'am.
then you are to file an application for condonation of delay in filing the revision, and the collector has got power also in view of the proviso. He has to consider your explanation, and if it is satisfied that has been shown for making that application, then it can be condoned. So as it appears, sufficient opportunity was given to you to show the reason for filing the revision after 90 days. So why didn't you avail condone karikini? Se seitpai apanku reason magile. Apan basiगले कहले कोविड रे एमती हला सेमती हला एगुडा को कहले सिना हबो ता बारे. So and if you explain now before us or give the reason, we are not to condone the delay. If you can
My lord, on if I submitted before the legal service, based on such document, I have also said, but is unable to answer whether the delay petition was filed or not. से किसी कोई वाला है असुविधा पचाची
ये ऑर्डर रु जा देखो जी फाइल हेई नथिला आपण लिखिले परा ऑर्डर टा क्लियर अछि ड्यूरिंग द प्रोसीडिंग सफिशिएंट अपॉर्चुनिटी वाज गिवन टू द पिटिशनर टू शो द रीजन for filing this revision after 90 days, which is beyond the stipulated period. However, the petitioner failed to submit any sufficient cause for shown. File heichi boli ko bhauten. Admittedly heini. That is as for the collector order which you are challenging.
Yes.
So, I would opportunity. Application. filed a fresh application, uh, uh,
Explaining delay.
explaining the delay. We are setting aside the order for this limited purpose, and you file the reason for filing the application beyond the period of so and so, and that will be considered in accordance with law without being prejudiced by the earlier rejection order. All right. Look, this writ petition has been filed by the petitioner, Niyasa Behera, challenging the order dated 21/2/2025 passed by the collector Khurda. कितने नंबर से annexure? Annexure कितने?
Annexure 8, page 31.
हाँ, पेज नंबर टा कितने?
31.
केस नंबर टा कितना? 31.
Case number WL 52 of 16.
कोड लिखा है. This
Yes, it's my first one. The case number 52 of 16.
WL case number टा होची, the order was passed by the sub collector.
Yes, my lord.
Why we are asking you the revision case number?
Yes, sir. On basis of the same record.
फाइल कर देले पचालेनी क्लाइंट को अपन गोटे ऑर्डर टा फाइल करचंदी चैलेंज करचंदी से ऑर्डर टा को केस रे ये ची तार नंबर टा नाही क्लाइंट को पचालेनी जे नंबर टा नहीं.
1 second. My lord, sorry, my lord. The revision petition 5/25. OGLS.
तेरा कौन दर्जेंदु?
It is the petition.
Petition. According to memo switch of file. The Land Council for the petitioner files the revision petition copy, which was filed before district magistrate and collector for the and number OGLS revision number 5/2024. The same is taken on the form. After letting them do the order dated 21/2/2025 passed by the collector and district magistrate Khurda in OGLS revision case number 5/2021. In rejecting the revision petition, mainly on the ground that such revision petition was filed beyond the prescribed period of limitation, which is 90 days from the passing of the order dated 11/6/2019 by the sub-collector Khurda in WL case number 52 of 2016. Stop. It appears from the said order that during the proceeding, sufficient opportunity was given to the petitioner to show the reason for filing the revision after 90 days, which is beyond the stipulated period. However, the petitioner failed to submit any sufficient cause for the same. Stop. Section 7A1 reads as follows. Therefore, even though the revision period prescribed is for 90 days, in view of the proviso, it empowers the collector to admit the revision application beyond the filed beyond the period of 90 days if sufficient cause is shown for not making the application within the stipulated period. The Land Council for the petitioner has taken grounds as to why the revision in the petition has has taken various ground in this writ petition for filing the revision petition beyond the period of limitation. However, since such grounds have not been taken before the collector and district magistrate Khurda, in the interest of justice, while setting aside the order dated 21 to 2025, we permit the petitioner to file an application for condonation of delay, enumerating the grounds for filing the revision petition beyond the prescribed period of limitation. If the same is done within a period of 15 days from today, by filing an appropriate application with the copy of this order, the collector and district magistrate Khurda shall consider the same in accordance with law without being prejudiced by the earlier order of rejection of the revision petition dated 21 to 2025. Okay? Accordingly, the petition is disposed of. Yes.
Item 18.
The memo is for.
Completely application has been allowed and estimated by calculation and submitted before the government for sanction. But under Annex 3 running page 29. Yesterday, item number 21, same.
এটা দিয়েছি 18/12/2024 ସାଂସନ ହେଇନି କଣ ଖାଲି ଅର୍ଡରଟା ପାସ୍ ହେଇଥିଲା ଅପଲୋଡ ହେଇଛି କେତେ ନମ୍ବର ଆଇଟମ
21
ଗତକାଲି ଦେଇଥିବା ଆଇଟମ ନମ୍ବର 21 ଦେଖିନି ଅର୍ଡରଟା କରିଦେବି ଡିସ୍ପୋଜ ହେଇଛି ତ
No.
ଆଉ
From the chapter vacation instruction.
ଆଚ୍ଛା ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଁ ସାଂସନ କେବେ ଦେବେ ଆଚ୍ଛା ଠିକ ଅଛି
Okay.
Item 19.
ସେ ଯୋଉ ଡେଟ୍ ଥିବ ସେ ଡେଟ୍ ରଖିନି ୟାକୁ ତା ସାଙ୍ଗରେ ପକେଇଦେବେ ଆଉ ଏକାଠି ପଡାଇବେ identical matter. Yes, item 19.
Item 19, Your Lordship, this is also the application pertaining to the pursuant to the directions of the Honorable Apex Court, challenging the order of the Claims Commission. The prayer is for structured compensation. Your Lordship, with earlier past orders, what I have done, Your Lordship, I have made a note because item 19 and 20 are similar.
Yesterday you had a couple of matters.
Yes, similar matters. So just to assist Your Lordship, I have made a note indicating the, yes, I have made a separate note indicating item numbers. And this is the copy of the common order.
ଦେଖିବି ଅନ୍ତୁ No, where is the order?
Let's order I have just handed over. Para 3 of the order, Your Lordship has recorded the prayer in the writ application. So that entire prayer I have made it into a note and handed it over to the Lords.
ଆମେ କହୁଥିଲେ ଯେ ଏଇଟା ଚେଞ୍ଜ କରିଥିଲେ
Paragraph 3 of the order that I'm.
Paragraph 3 ରେ ଖାଲି ଏଇଟା ଚେଞ୍ଜ ହବ
Yes, my Lord. The prayer will be just changed.
That's not ଆଚ୍ଛା ଏଇଟା 20 ନମ୍ବର ଏଇଟା କେତେ ନମ୍ବର
90
ହଉ
The rest of the part will be
The rest of the part is same, opposite parties are same.
ତା ଦେହରେ ଏ ପ୍ରେୟାରଟା ସିରିଏଲ ନମ୍ବର 19 ର ଏଇଟା ହଉଛି ଆଇଟମ ନମ୍ବର 19 ଏ ପ୍ରେୟାରଟା ଚେଞ୍ଜ ହବ ଆଉ 20 ର ଏଇଟା ଆଉ ବାକି
rest of the things
ଇସ୍ୟୁ ନୋଟିସ୍ କରି ଯାହା ରହିଛି ସବୁ ରହିବ ହେଲା ଇଏ ଇସ୍ୟୁ ନୋଟିସ୍ ଠିକ ଅଛି
Item 21.
Mr. Beura, Samarendra Beura.
May please your lordship. Lordship Simon VC.
Yeah.
Lordship, the case of the petitioner is that state government has constructed a road on the land without
So,
payment of
what is the earlier order which we have passed in other cases?
Your lordship, my associate will hand over in writ petition 9988.
Here is a case, my lord. Embankment was constructed in work of 1982. Now the Pradhan Mantri Gram Sadak Yojana is approved there. So the land was the embankment was developed. There is no need and requirement of acquisition of land. On the existing embankment, in order to create a connectivity to the area, the PMJC is introduced.
I beg to defer your lordship. This is not a question of an embankment.
Yeah, I mean, खाली वही चीज है अपन इंस्ट्रक्शन नेबे
Yes, that instruction in other case we have received.
नहीं यार ये खाता नंबर घरिया अलगा सब अच्छी तो ते मेरा पारा 8 रे
पारा 5 रे page 7
नहीं आधे रे से केस रे थिला पैराग्राफ नंबर 8
नहीं एथरे पारा 5
तो ती खाली चेंज हो एटा वो 5 अब बाकी तो सब समान लेबो केस नंबर चेंज हो पार्टी ना चेंज हो है ना एडवोकेट से ये सब ऑप्शन थी डेट ऑफ ऑर्डर चेंज हो ऑर्डर नंबर चेंज हो देखी करिए yes we obtained that instruction yes.
Item 22.
Lordship, any date before vacation?
Yeah, sure. Next.
Obliged.
Item 22.
No, Lordship. Lordship, previously the order was to change the container name. So that's why I have already filed an IA for the present office bearer of the NHL.
IA has been filed for amendment or what?
Yes, Lordship.
Oh, container transfer ही रहने तारो बदली ही रहने वर्तमान हो श्रीमती अक्ता कुमारी अच्छा पहले अपन करो फर्स्ट टाइटल चेंज करियो पड़ियो काली गोटे मैटर थिला ना कोन आज काई ऑर्डर काई डायरेक्शन का होइछ ये अक्ता कुमारी के इंसर्ट करियो कोन नहीं ऑर्डर पास करती हूँ आइए रे गोटे ऑर्डर पास करती हूँ भाई कालना पहर दिन allow कलु लेकिन IA number 1 this is an application for amendment of the correction of the name of the container from Sunil Kumar to Srimati Akta Kumari. The land counsel for the petitioner stated that Mr. Sunil Kumar has been transferred and Srimati Akta Kumari has joined in his place as the General Manager Technical National Highways Authority of India bracket NHAI is one and therefore he may be added as the contemner in this contempt petition. So after hearing the land counsel for the petitioner and going to the amendments taken in the interim application, prayer is allowed. The land counsel for the petitioner shall file a consolidated first title. You will file करिए? हाँ?
Sir, any day.
Any day मैंने अपन file करूँ ना any day कौन? आज ही file करूँ?
already been filed there also.
Good.
Consolidated.
ये जो नाटा काटी हुए है
Sir, within a week.
ऐसे एक पता हुआ कौन कुछ filed? Already filed. The land counsel for the petitioner submit that 1 week time will be granted to file the amended cost title. Permission is granted to leave this matter after summer vacation ensuing summer.
But item 23 was similar matter.
23.
Yes, Lordship. Published.
Item 24.
आइए तो allow करी dispose of कर दे, है ना?
Some 24 allotment is opposite, but in sitting is not attachment allotment. Senior is not well allotment.
Which for the petitioner?
I am there for the petitioners, Your Lordship. I am in VC. Sorry.
So you are appearing for whom?
Opposite party allotment. On behalf of Shikhar Kumar.
No, how many opposite parties are there?
No, there are 45 disputants, Your Lordship, and he is appearing for possibly all of them. And in fact, there has been an order for him to file the authorization so that the amount which we have deposited, that he will take back. And I think he has filed that compliance affidavit 14168 of 2024. But let him come, Your Lordship, any day, Your Lordship, pleases. The matter can be disposed of also.
Mr. What is your name?
Akash Chaudhary.
Mr. E. Chaudhary, Land Council, appearing for Mr. Srikar Kumar Rothon, the Land Council for the opposite party, seeks for an adjournment. Mr. Mishra, advocate, has no this objection for such clear of adjournment. Please, this matter give a date. Now, they can execute a date. Yes, next.
Can it be, Your Lordship, after the vacation?
Yes. Mr. Mishra is present through virtual mode for the.
Yeah, Lordship.
Yes.
Item 25.
Yes, Mr. Rao.
Against the punishment awarded against me, which I have acknowledged in the tribunal and having lost bail before Your Lordships. But the charges leveled against the petitioner.
You are having the records with you.
There is a noting that all the records are kept in the field cover.
Record is there.
No, that is with you. We are not keeping it. We are it over to you, and because the Land Council for the state has produced the records of settlement revision number 88 of so and so, and also miss case number so and so with the order sheet. Let it be kept in a sealed cover, and the same shall be handed over to the registered judicial. So it is there record. It's all right, but so we are taking up this matter tomorrow. You bring that report. That is because without record it cannot be appreciated. Mr. Rao, it will come tomorrow. Then this matter, the records of settlement revision number 88 of 1992, so also this case number 28 of 1994 with order sheet, which was kept in a sealed cover with the registered judicial as per the order dated 10/2/2025, we produce tomorrow.
Item 26.
26 will also the time that's over the last order. I had supplied the copy of the order passed in other similar matter.
26.
26.
26. So I am also appearing. I am virtual mode, my lord. I am writ appeal number 1194 of 2022.
Yes, 26, my lord. Even though the order was handed over, that similar matter was disposed or withdrawn by the state. but we have in consultation with the Learned Advocate General, matter is pending for discussion. Because some of the similar matters are pending for the Honorable Appeals Court. We have to take note of that. I pray for Tuesday.
No, here you have withdrawn.
You withdrawn.
And then you have challenged.
No, that's why the other matter pending for discussion.
That matter was pending before this withdrawal order was passed.
Because
this writ appeal,
discussion
for that the matter is one matter is pending, that is subject matter is different, madam. Not.
So you want it on Tuesday?
Tuesday.
What they are saying that if you have similar matter, you have
there are in
withdrawn.
consultation with the Learned Government Advocates.
It's a
That is said that we have not make any mention, but order was passed. I cannot dispute. That's why that's why on that, because without create any necessary problem, I prefer Tuesday or Wednesday.
The Land Council for the state submits that the matter may be taken up on 3rd for them to obtain necessary instruction. Release this matter on 6th of May. Tuesday, 6th of May 2025. ये जो WA गुड़ाक अच्छी सब गुड़ाक से क्या चलो गोटे के फास्ट करे ऑर्डर टा पास करेंगे 432 रे बाकी 383 है ना
Item 27.
My apologies again for the fact copies are in the lordship read at the first fact copies made. Hey, court master. Now, madam, before your lordship come to annex it to you, the release to you. Would my lordship please to go to the synopsis first? I'll take you also to the synopsis, it's very brief. Then the list of dates in the event, and show it to your lordship how falsely so-called preliminary counter appeal stated and what a grotesque action has been taken by the state in appropriating and reprobating same land in the language of the Supreme Court. And put my lordship down to page 8. Page 8, the synopsis. No, I'm not going to read it. Synopsis of the main.
Yes, please.
No, Mr. Mishra was not there. But the state government authorities, state undertakes and whimsically and arbitrarily alienate a substantial portion and parcel of the land leased out in favor of SBI under long-term lease of 90 years with option for renewal in favor of third parties, be it governmental undertakings or otherwise, without any notice whatever, far less a short or notice, and or any procedure known to law for cancellation of the lease. This matter has been directly hit by the Supreme Court, saying in the, I'll try to tell you to it, that we have granted a lease for a particular area. We can further lease over the same area to a third party. Of the terms, more particularly in the case of the evict, position that despite the existence of registered deed of lease, under which a 90 years lease was granted to the petitioner, the repeated communications of this matter is important. That and it's supposed here is the repeated communication of the petitioner is unable to take actual physical possession of the area in question because of squatters and slum dwellers, and the object party, despite all such communications as aforesaid, they have merely been sitting over this matter and have taken no steps in letting the slum dwellers and squatters removed or evicted from the land, then unilaterally and without even a notice to the petitioner, indulge in any such alienation by the government order so, and further be allowed to fabricate, come up with wholly false and factually unsustainable, legally untenable purpose justification, trying to assign the blame to the petitioner to the effect that since the petitioner did not put the land to any useful purpose, the construction of shaft quarters further led to squatting upon them. With this, my lord, they totally false, but I'll show it from the records.
So reason for revoking or resuming the land was that it was not used for the purpose for which it was given.
Been used in what that grant the lease deed.
Yeah.
86.
86, no, these are 86, 94.
Possession.
Possession. Stay in 94 within a matter of few months, I write to the state government. It's impossible for me to get into the land. It's full of squatters and slum dwellers. Kindly clear the and give me vacant possession. State government, despite communications right up to 22, 23, 6 over all such letters, that is respond taking one of them, and then suddenly we see, after alienation, almost 90% of the land in favor of the government taking, and I'm informed of that 12 years after the date of so-called alienation.
And I'm paying the rent.
But this is a state governed by the rule of law.
And I'm paying these rents.
And I'm paying my land revenue right up to 23, 24. They accept my land revenue.
No, this date chart which you have filed along with the synopsis, it indicates that physical possession was handed over
Yes,
to the
94.
SBI on 16/5/1990. Absolutely.
So
the position was only massive demarcation with Amin, that stated by the repetition. And
now,
the same
if it is handed over the physical possession in 1994, and the purpose was for establishment of a training institute at Bhubaneswar, then what prevented you to carry forward that
That's exactly what I'm conveying to your lordship. The entire land was enforced by slum dwellers and squatters. Very 94 itself, I write to the state government, please give me vacant possession of the land. And I keep on writing my 17 letters till 1922-23. None of them he responded. Not one.
The question is that why you took the physical possession, land was
I could not take physical possession. It was 94 itself. Amin really came and demarcated the boundaries. Nothing else. That's part of my writ petition that's not been denied. And thereafter, my lords, when I started constructing the boundary wall, on the 3 sides I have constructed, both sides, they came with daggers and spears and said, we'll murder you. Our labor and officers were beaten up. This is all part of the writ petition. That leprosy, that nobody risks his life for an institution, unless in the armed forces. And then I keep on writing the government endlessly. And not one of the letters has been responded to. And it's a course series will demonstrate that. Right from 94 till 22-23, I have going on writing. And on the one hand, government accepts my lease rent for the entire 5 acres, of which 4.83 acres have been alienated.
We got to 23.
So when the resumption took place,
No, they have not taken payment.
There's no resumption, no?
then
There's no notice also.
There's no notice to us.
then what they have
In
done?
one of our letters, after a period of 12 years, they say, after 12 years from the date of so-called alienation,
Yes.
that because we didn't put the land to any useful purpose,
We have given it to.
we have given it to a governmental agency for construction of land for the.
No, ultimately what they have held, we said,
I beg
since
your
you are not using that land,
You did not put the land to any useful purpose.
where is that order?
That's a.
That's the improved order managed.
Annexure,
Improved order managed. What the hell are you working about? Man, it's a lot of place implement it.
You have just announced them. I think it's annexure page 4.
Page
44, annexure page.
44, 45.
Yeah, it's page 45.
Which is that order of alienation?
That is page 45.
This is a site selection committee proceeding held on 2012. While examining the issue, so many allotments in favor of the government and other agencies. There it is found that some of the lands which are allotted in favor of the state institution other are kept vacant and not being utilized. For which under annexure B/2 annexure, there is a sites committee election comprising officials of the state. They decided to re-alienate land for development purpose. Without kept in vacant.
Yes,
The possession is handed over in favor of.
Mr. Mahanti, suppose let us say you have given a particular piece of land to the petitioner for establishment of what is that?
Training center and subsequently rectified did staff quarter.
Staff quarter, ठीक है. So when you actually handed over the possession, it was found that there were encroachment, and he was repeatedly sending letters to you that vacant possession. So the laches was on your part. So that caused the delay in starting the project. And ultimately, now you alienated the
One thing
land.
I may submit, Mal, if the land was handed over 1994, that the petition is produced the approved plan from BDA when plan was submitted for approval. There it shows the intention for construction. In the development area, unless the plan will be approved by the competent authority, no development can be, construction can be made. In 1994, possession handed over.
ଆପଣ ମୋ ଯୋଉଟା ମତେ ଦେଲେ ଗୋଟେ ପଜିସନ ଦେଇଦେଲେ ତା ଧିଏରେ ଏନକ୍ରୋଚମେଣ୍ଟ କରିଛନ୍ତି ସବୁ ଅନଅଥରାଇଜ୍ଡ ଏନକ୍ରୋଚମେଣ୍ଟ ଅଛି ଆପଣଙ୍କର ସେଟା ଫ୍ରି କରିକି ଦବା କଥା ମୁଁ ଆପ୍ଲାଏ କରିଦେବି ଆପ୍ଲିକେସନ ଦବ ଏବଂ ଆପ୍ଲାଏ କରିଦେଲା ପରେ କହିବେ ଏଇ କନଷ୍ଟ୍ରକ୍ସନ ଟାକୁ ଏତିକି ବର୍ଷ ଭିତରେ ଆପଣ କ୍ୟାରି ଆଉଟ୍ କରେন 3 ବର୍ଷ 36 ମନ୍ଥ ସେତେବେଳକୁ ଏଇ ସବୁ ଜମି ତ ଅକ୍ତିଆରରେ ଥିବ ମୁଁ କନଷ୍ଟ୍ରକ୍ସନ କେମିତି କରିବି So he might be waiting that let it be clear.
Yes.
Then I will submit the approval for.
To that effect, the counter shall not take instruction, but the plan.
What counter file question?
Generally,
generally, जे पर्यंत से गोटे vacant position न नहीं से पर्यंत से केमती अप्लाई करिवो आपण जो कोनी प्लान कोन पई
plan approval something otherwise.
That आपण बोले पूरा एग्जांपल देले गुटे एग्जांपल देले जे तार इंटेंशन काहे
नहीं प्लान आपण जेबे आपण पथ allotment possession दिया हो immediately plan approval दे
It's not an individual, it is a financial institution.
नहीं
What am I learning for quoting minor?
Without institution
And in the representation in annexure 4, if you see it, page 46, they have expressed their inability to construct because of stiff resistance by the villagers and all. As of now, we are unable to construct the staff quarter because of illegal encroachment and stiff resistance from the illegal settlers.
So you are shifting the burden to them, but the laches is on your part. So you are not giving the vacant position, and you are saying that they have not applied for the approval of the plan. So there was no intention. So we have taken the right decision.
No, not right decision. Some land which is not being utilized, even though allotted.
No, utilize. How will they utilize?
How they will utilize? Just
the fact of the matter is, you are not able to remove the encroachers. Therefore, you are recalling this.
That goes to
that's the fact.
Crux of the matter. Upon counter affidavit. अच्छी की जे आज्ञा से जमी रे कोनोसी एनक्रोचमेंट नथिला ये जो चिट्ठी गुडा का देइचंदी रिप्रेजेंटेशन इट्स एब्सर्ड एमती कोनोसी इज इट योर ग्राउंड दैट देयर वाज नो एनक्रोचमेंट एंड फॉल्स रिप्रेजेंटेशन वाज फाइल्ड दैट इज नॉट योर ग्राउंड एंड यू आर नॉट सबमिटिंग एनी रिप्लाई आल्सो टू दैट जने रिप्रेजेंटेशन देला आपण चुपचाप ही बसी गले सी गला रिपीटेडली रिप्रेजेंटेशन देइ चलचंदी.
So it's an institution, it's not the individual.
The bar rule and I'll take instruction to that aspect, what steps they have taken on representation submitted on under annexure 4.
When the state is taking 4 adjournments but pending instructions, they also looks at the audition.
You see, he's right. This matter has already, we took up this matter first time, no. This court took up the matter first time on 29/4/22. Previous bench on case. All right, you take the instruction in that. The Land and Council for the petitioner placed the date chart from which it appears that way back in 1986, the lease deed was executed in favor of the petitioner. By the government for establishment of training institute at Bhubaneswar. However, physical possession was handed over to SBI on 16/5/1994. It appears that since the allotted land was not encroachment free, repeated representations were submitted by the petitioner to the concerned authority to give the vacant position of the land, but no response has been received. And ultimately by virtue of the input later dated, order dated, for example, 31/2023, it was intimated to the petitioner that the land patch remained unutilized and hence was enclosed public converted to slum, namely Munda Sahi Basti and the Mandapa Basti.
In the year 2011.
And the government land measuring acre 4.803 out of the same land patch was alienated in favor of H&UD department for rehabilitation of the slum dwellers of Munda Sahi, Basti and in the year 2011. And the BMC is developing the project with the alienation order. And therefore, it would not be possible to allot this same land to the SBI. It is the contention of the Land Council for the petitioner that the fault lies with the government for not giving vacant position of the land for which the project of establishment of training institute at Bhubaneswar could not commence.
And name alone.
Yes.
Changed to staff works.
Which was subsequently
Staff works.
Which was decided to construct staff quarters for the SBI.
Yes.
For the SBI. Though the Land Council for the state has filed the counter affidavit and rejoinder affidavit has also been filed by the petitioner to the said counter affidavit, Land Council for the state seeks some time to obtain instruction as to whether any action has been taken by the government in pursuance of the representations filed by the petitioner time to time for evicting the encroachers. Put up this matter. Take the instruction.
One more.
Yes.
We pleased to know that despite that land was alienated in 2011 by the annexure of 1 Marriott on 31/23 have been intimated. 31/23. 2011 they alienate my land.
It's a bad thing.
Then lots of imagine this happening.
2011 was list रे जो डेट रो जो चेंज ये था कि सेटा को इनकॉर्पोरेट कर देबे एवं 23 रो 31/23 रो सेटा को इनकॉर्पोरेट कर देबे ना shows the draft to correct.
Could you also please to give me a date?
No, we have to keep it after summer vacation.
I don't mind, but keep it fixed.
You can know it in the evening hours. We'll upload the order in the website so that you can know it.
I'm already 81 now. My days are limited.
No, we are.
No, I'm saying yes. I like to wind up and then you can also pull up. Keep looking.
We are just coming within 2 minutes.
Item 28.
In item 28, I am from the petitioner and the matter relating to appointment under rehabilitation and resettlement of land minor. So I will only want to matter will be listed next week. Tomorrow I will file the rejoinder so that the counter filed by the NTPC is concerned. Matter will be taken up next week.
But rejoinder has already been filed and reply to rejoinder has been filed.
Item 28.
28th of WPC, huh?
Yes.
It's 28 only.
41325.
41325, pra?
Yes.
It लिखा further affidavit by the opposite party to the rejoinder affidavit, reply to the rejoinder affidavit.
All pleadings are complete.
So,
हमको read petition number कितने आपको?
41325.
It is Rajesh Kumar Pani.
Yes, yes.
The pleading is complete.
Not rejoinder.
Rejoinder not received.
No, received no.
No, the earlier there is earlier.
नहीं reply to the rejoinder.
ये कौन लिखा है इसको?
Reply to the rejoinder.
नहीं cause list में.
No, it is in some.
देखना सेठी देखो.
सेठी
से बसी ची कौन सी?
It is गलत लिखा है. It will be. This is related to 9268. Read petition ऊपर 51 ऊपर है.
Preliminary counter affidavit by OP1 and counter affidavit by OP213 copies of rejoinder not.
No, no, year. See that site जो reply to
Affidavit of number 4.
That was in the earlier.
No. All right, the Land Council for the petitioner submits that he has received the counter affidavit filed by the opposite party number 1 source opposite party number 213.
Yes.
And he intends to file the rejoinder affidavit and 1 week time may be granted. Put of this matter on such and such date.
I will take only one week penalty after the rejoinder is filed.
Acha.
Tomorrow I will
copy of the rejoinder affidavit be served on the Land Council for the opposite party, respective opposite parties. Mr. Tripathi, Land Council Senior Advocate, submits that after the rejoinder affidavit is filed, we will take 1 week time for verification of the same to file additional affidavit, if any. Put of this matter after summer vacation could be our timeline.
last week.
Like government has also filed a counter, but let a copy of that counter.
The Land Council for the opposite party number 2 and 3. No.
One man.
I'm one.
One.
Yes.
One submits, Mr. Tripathi, Land Senior Advocate, submit that he has not received the copy of the counter affidavit filed by the state. Opposite party number 2 and 3 though?
Yes.
Let the Land Council for the state supply the copy of the counter affidavit to the Land Council for the opposite party number 1 in the meantime. Yes. No, it is not possible. We have posted number of cases in the last week, so it is not possible. Yes. And yes, you just see the date in the evening hours.
Yes.
We are uploading the order every.
Item 29.
Yes. What is this writ appeal for?
Against the judgment of the Honorable Single Judge, where my resident certificate has been cancelled.
Annexure 2.
Annexure.
You are challenging?
Yes, sir. Yes, sir. 1 and 2 both I have challenged. One is the review also I have filed. Lordship said, Single Judge said, you correct him in the appeal because there is an error on law matters.
Just a minute. So the first order was passed under Annexure 2.
My lord.
So that is the single bench order.
My lord.
So
Annexure 1.
what was your prayer in the writ petition?
It was not filed by me, my lord. It was filed by the respondent.
What was
prayer was they have challenged the order of the sub collector, order of the
Tahsildar. Both the order were challenged in the writ petitions, my lords.
Order means one key order.
Order is, my lords, granting residential certificate to me, this appellant, by the Tahsildar, and subsequently appeal also confirmed, my lords. The concurrent finding of facts in my favor, certificate is granted to me.
Okay.
I am serving as a Anganwadi workers, my lords, and this is from 2005, my lords. And earlier, a writ was preferred by the respondents, my lords, in which your lordship was directed to the collector to find out the dispose the representations given by the respondent of 2 months. In that representation disposed of, with confirming finding of fact that resident certificate has been correctly issued and my service is manner confirmed by the collectors. That order never challenged matter. Then the respondent filed one application before the suppletter challenging the issuance of a resident certificate to me. That Tahsildar minors confirmed. Again, they come to the writ court. The writ court again remanded the matter to the Tahsildar. Tahsildar finally gave in my favor. It's correctly issued. The certificate is correctly issued. Thereafter, it was, my lord, appealed by the respondents, and suppletter also confirmed. And subsequently, it has come to my lord in writ petitions. In writ, my lords, what has happened, my lords, in 2023, my lords, lordship so much added TPCUDL, my lords, an electricity company, to go and inquire where the meter, my lord, is installed. This inquiry, my lord, subsequent reappreciation of fact is under challenge. In a society, my lords, this is not possible. First. Second, my lords, lordship was proceeded under the wrong rule, 2017 rule. I was granted my certificate in 1984 rule, my lords.
So you are appealing for that Jaswanta?
Jaswanti Sahu.
Jaswanti Sahu.
So I have been serving 6 to 2 minutes.
Just a minute. So Jaswanti filed the writ petition. That is WPC 716 of 2015, which was allowed.
Yes.
And as it appears, the resident certificate and order dated 6 March 2014 and 25th November, that's set aside. So that was issued in your favor, right? And you, against this single bench order, you preferred a review petition.
In the review, lordship said, you corrected in the appeal. That's why I filed writ appeal, my lord.
Where is that review order?
My lord.
Where is the review order?
Two miles. Annexure 2.
No,
Annexure 1.
Annexure 1. Annexure 1. Let's see page 31. Paragraph 3, my lords.
Okay. Now
there
you
has
come
been
to the
incorrect
rejection. Now you come to the
There is missing of some pages, matter will take next week. Some pages are missing, let the matter be taken next.
6 times.
You are for the opposite party number in this writ appeal. You are for the opposite party number
Private respondent.
1. Opposite party, respondent number 1. All right. The learning council for the respondent number 1, 6 for an act and this matter. Date here.
Item 30.
Minutes after petition.
We'll see the right if it is possible, otherwise it after. Yes.
Please.
But the exact date you can know in the evening hours. Just to verify. We'll upload the order. Yes, item number 30.
Wait, please, Lord. I am for the petitioner, my lord. Writ petition relating to tender, my lords. State has not filed a counter. Private opposite party number 2 and 3 have entered appearance.
A counter is not required. It's a OSMCL tender, my lord, which has been quoted by the Orissa State Medical Corporation. So Medical Corporation has filed its counter, my lord, opposite party number 2 and 3.
My lord, I am appearing for 4 and 5, my lord. I am in virtual. 4 and 5. I am just adopting the counter filed by the opposite party 2 and 3. I have filed a memo.
My submission is that state's counter is necessary because if the lordship sees the bid document, then
The state will decide. State will decide.
My lord, the purchase order has already been issued. We have to supply.
supply is mandated to be completed by May and June. So almost the time is over because of the stay order. We are the successful bidder. 4 and 5 are the successful bidder. They have already. There is an interim order passed. Yes, my lord. The supply has been stopped. The order has been issued. Supply has been stopped by virtue of my lord's order. So why are you insisting for the state's counter? Because if a interim order is in your favor.
No, not because of that, man. If the state doesn't wish to file its counter, fair enough. Because it's a
They are not
tender which
saying
is floated by.
they are not saying anything.
Yes.
So the other side have already filed the counter affidavit. Opposite party number 2 and 3.
2 and 3.
And the other opposite parties are adopting that counter affidavit. So why are you insisting the state to file the counter affidavit? What purpose? And you will get time and you will get you will pray for extension of the interim order.
I will, if the lordship permits me, I'll file my rejoinder.
That is different matter.
My lord.
You can file the rejoinder affidavit. That's no, but
the time-bound supply contract.
My lord, 3 months time. Already almost 2 months over.
Time-bound supply contract, you can't, for pleading, you can keep on asking for time.
If your lordship permits me, my lord. Why I say that the state should file, I'm not insisting that the state file a counter. If they do not wish to file a counter, fair enough. Because the bid document, if your lordship sees, this is a tender floated.
You intend to file any counter affidavit. Let us be clear.
Document against the state, my lord. That is 7 is the interim order.
We are asking a plain and simple question whether the state intends to file any counter affidavit or not. Because some interim order is in his favor. If you say no, then he may file the rejoinder affidavit. We can take it forward.
The state did not want to file the counter.
We are recording it.
My lord, annexure 3, page 24, just for a moment, your lordship.
Council, he is deciding. Why are you insisting?
No.
The Land and Council for the state submits that state does not want to file any counter affidavit to the writ petition. Stop. Counter affidavit has already been filed on behalf of opposite parties number 2 and 3. Stop. The 4 and 5. The Land and Council, Mr. Mahapatra and Senior Advocate, appearing for opposite party number 4 and 5, submits that he is adopting the counter affidavit filed by the opposite party number 2 and 3. What about opposite party number 6?
They have not filed any counter. I don't think they're.
No, it's all right. The notice is sufficient.
Notice is sufficient. Notice is sufficient.
All right. The Land and Council for the petitioner submits that he has received the counter affidavit filed by the opposite party number 2 and 3, and some time may be granted to file a rejoinder affidavit. That is your concern. So you file it by next week, and I will file the rejoinder affidavit by next week. Okay, put up this matter on such and such. A copy of the rejoinder affidavit be served on the Land and Council for the opposite parties number 2 and 3. So also the Land and Council for the opposite parties number 4 and 5, and also 1, 2 and 3, and 4 and 5. Here. And the date you will know in the evening hour.
Deeply grateful, my lord, if an early date is being given.
We'll see. Just we're trying it.
Well, the interim order.
And interim order dated so and so. I am affected already. 2 months over.
One thing was my name be recorded.
What is your good name?
Vishal Vaibhav. B. Vaibhav.
Mr. Vishal Vaibhav, the Land Council for the petitioner, and Mr. Tripathi Land Senior Advocate for the so and so, Mr. Mahapatra for so and so, Mr. Nayak for state. So Nayak for the next.
Grateful.
Item 31.
You have counter not received, Lakaiji?
I have not filed a counter application of time.
Counter ready?
And the officer was sending the letter, but the officer has not come.
Officer has not come. So Acha, the lease application was disallowed and a detailed order has been passed, quoting the provisions of the OGLS Act and rules, then OPLE Act at the time of issuance of notice. So, polite land council for the state take some further time to file the counter affidavit, put up this matter, give it date. Here.
Item 32.
May I please?
In this case, the petition is challenging the illegal enforcement of the opposite party number 2 for widening of the NH 143H matter. The Lordship kindly have a glance on the annexure 2, my lord, the gazetted notice matter.
We are appearing for the Union of India.
My lord, I am appearing for NHI. Oh, sure. Sorry.
You have solved the consolidated cost title.
No, my lord, they have not solved it. Sorry.
Not solved due to my health. Solved. Yes, my lord. I have received counter matter and I will file the rejoinder.
The Learning Council for the petitioner submits that you will solve the consolidated cost title on the Learning Council for the Union of India by next week. Stop. He further submits that he has received the counter affidavit filed by the opposite party number 2 and 4.
Two.
Better
No,
likha ye 2 and
no
4.
4 is there, my lord, in the writ application.
Huh?
No 4, opposite party number 4 is
Oh, nahi gaya. The reason is 2 and 4 लगती है.
2 and 4.
Bhule lag division. Consolidated cost title with 4 nahi. अच्छा. Cut out of form lag division. That is opposite party number 2.
My lord, ମୋତେ जोड़ा copy ଦେଇଥିଲେ, in that copy.
Party number 2. Your counter affidavit. We have to adjudicate the matter. So just wait for his rejoinder. We have not passed any interim order. So the Land Council submits that he may be given some time to file the rejoinder affidavit. Release this matter on such and such date. Yes, next.
Item 33.
33, my lord, I beg your pardon to submit, my lord. I am appealing for opposite parties number 2 to 4, my lord. My lord, I have received the parawise. If my lord may give me 1 week.
2 to 4 means who? 2 to 4, acha.
Yes, sir.
ESI Corporation.
My lord.
Okay.
If my lord may give me 1 week time, I have received the
Just a
parawise.
minute. What is your good name?
Nihal Ratna.
Mr. Nihal Roth, Land Council submits appearing for opposite party number 2 PO24 submits that he has received the parawise comments and he will file the counter affidavit within a week and the matter may be adjourned to some other date. Put up this matter on such and such date. Counter affidavit be served on the Land and Council for the petitioner. So also the Land and Council for the Union of India.
I am appealing for the Union of India.
Union of India. Now, Gopal.
Yes, my name is there.
Yes, next.
Item 34.
Item 34, there is instruction to take instruction, but we have not received any instruction.
Yes, Mr. Padi, what do you say?
My lord directed to obtain instruction. We didn't have any instruction, also keep it to after vacation.
issue notice on the question of admission to hitla. Interim order, pass HE. Acha, this will not be a bar for releasing the admitted dues. Acha, theek hai. So order has not gone against you. So we are adjourning it to after summer vacation. That is
Yes,
your
madam. I'm praying.
Party Land Council, Deputy Solicitor General submit that the matter may be taken up after ensuing summer vacation so that he will file the counter affidavit. List this matter on such and such date. Yes.
Item 35.
35, contempt petition.
For the opposite party, contempt show cause has been filed.
Non-counsel for the contempt opposite party is present, non-obvious for the petitioner. List this matter after summer vacation.
I'm grateful, my lord.
Sure.
Pass over item number 14.
Next.
Item 15.
My lord, item 15 will be taken up 1 week after, my lord. I am out of station.
14 with the non-obvious after vacation. 15, Mr. Namutra appearing through virtual mode. 6 for an adjournment. Adjourned. Next.
I may pardon to mention, my lord. The petition is postponed 10 years. Daughter marriage is fixed on 7/5/2025.
7/10.
No, 7/5/2025. Those jewelry to family.
April of the year 2017. I have filed an interim application for bail.
Give it.
My lord, item number 8, my lord.
Yes.
After vacation, my lord, I pray.
Yes, next.
Obliged.
I may be pardoned, my lord.
Yes.
Item number 35, my lord. I have some personal difficulties. May I pray after vacation? Item number 35, your lordship.
It's just note better. Yes, next.
Item 28, my lord.
Obliged, my lord.
Behalf of sub-item that on behalf of Gagan Singh, I pray, my lord, any after vacation. 28.
Just see. Yes, call for the
Supplemental list. Item 1.
Here is the report furnished by the Superintendent, District Jail, Internal Welfare Services, dated 16/4/2025, which indicates that the appellant has been released prematurely as per the order of the Government of Orissa Law Department, Bhubaneswar, and Directorate of Prisons and Correctional Services, Odisha, Bhubaneswar. In view of such letter, this criminal appeal is disposed of if the petitioner intends to challenge the order of conviction, is at liberty to file an interim application for recall of this order. Yes, next.
Item 2.
Item 2, he has already surrendered. On dated matter 25/2/2025. Why the surrender certificate? Certificate copy. How can we know that you?
Last time you have taken time to file surrender certificate.
When he has surrendered? My lord, on 25/2/2025. That submission also you made on the last date, and we asked you to produce the surrender certificate. The London Council for the appellant submitted that he has received instruction that after availing the interim bail period as per order dated 28/10/2024, the appellant has surrendered before the London Trial Court. Since the London Council is not producing the surrender certificate, let instruction be called for from the London Trial Court by the Registered Judicial as to whether the appellant has surrendered after availing the interim bail period or not, and if not, what coercive steps have been taken for his arrest. File be placed before the Registered Judicial to do the needful. Matter be placed in the week commencing from 12th of May 2025. Yes. Okay.
Item 3.
Madam, Mr. Arun Kumar Das is undergone surgery. May I submit on his behalf?
Jail criminal appeal cannot be.
Nice.
So, in sub item,
I pray for an adjournment in that.
Oh, that is. Let on. A mention is made on behalf of Mr. Arun Kumar Das, that is JCRLA 15 of 2021. For adjournment on the ground that the London Council is indisposed of put up this matter after ensuing summer vacation. Yes.
In sub item, your lordship,
Yeah.
CRL number 387 and 19. My lord, here, this application is subsequent bail application with the laws. My lord, in this connection, the appellant is in custody near about 8 years, your lordship. That is on from.
No, you see, there is a noting
My lord,
that
there is no-
earlier it was rejected by me and Justice
My lord.
C.R. Das, and since both of us are available, so it is to be taken up by the same bench as per that litigant. The registry has placed a note that the earlier bail application has been rejected by a division bench consisting one of us, bracket Lakijantu, Honorable Justice S.K.Sahoo, bracket ends, and Justice C.R. Das. Matter
23/7/24. your lordship.
that matter will be placed before the same bench. Yes. For consideration of the bail application.
Item 4.
Yes.
This is for the interim bail application. And ultimately, the lordship has sought for some instruction regarding the interim. The mother of the appellant was only having joint pain. There are other male members in the family to take care of her. That is my instruction. I'll submit. PD ticket is also included.
तो चिकित्सा हवाकू डिस्ट्रिक्ट हेडक्वार्टर हॉस्पिटल अनुगुल रे अपन मां चिकित्सा आइकिन आछंती आउ अन्य मेल मेंबर भी अछंती
In the month of January 2025, he was coming to the
And it's
SCB
still
medical,
only of
medical and
it is around only 50 years.
हां 50 years नहीं जे से
ସେଇ ଟାଇମରେ ତାର ପ୍ରୋବ୍ଲେମ ଥିଲା ଜାନୁଆରୀ 2025 ଏଇ ଜାନୁଆରୀ ମାସରେ thereafter doctor advised for some test and only the father is there परशुराम calling
जो
the
ओपीडी टेस्ट येटा रिपोर्टटा देइचंदी किछि लेखाइनी कोन टेस्ट कोन किछि नाही खाली जॉइंट पेन लेखाइ जॉइंट पेन आजिकल तो अधिकांश को जॉइंट पेन
January 2nd January 2025
आपण गोटे पर्टिकुलर ग्राउंड टा नउचंदी इंटरिम बेल पई रिपोर्ट ए आसिला एई ग्राउंड रे केमती आपण को घरे अन्य मेल मेंबर्स भी अछंती आपण को फीमेल भी अछंती तापर 2-1 रे लास्ट ट्रीटमेंट आपण हेतिले डीएचएच अनुगुल रे आ बाकी कोनोसी अन्य हेल्पमेंट किछि नाही
January 2-1 रे एससीबी रे हेतिले
जो
हां
से लिखिजंदी डीएचएच अनुगुल तनु
एससीबी रो देछन
हां
एससीबी रो देछन
She was to DHS Anupul and one private hospital, Smile organization. I went for one of
तो ये तो नुहे किछि हां जोटा अर्जेंसी थांता आपण नगले ऑपरेशन टा दरकार अपन नगले हेई परिबोनी
ट्रीटमेंट पे मेल में मना भी केवल only the father of the petitioner is there no सीरियस लेवल घरे अन्य लोक आछन रिलेटिव देयर इतो जाइथिले पुलिस जाइथिले आज इनक्वायरी पे एबे
रिपोर्ट पर देजन और इंक्वायरी न करी कोन रिपोर्ट टा देजन ए के 5 रो रिपोर्ट दिस इज 2 days रिपोर्ट
हां 2 डे जी जाइथिले पांचटा बेले फोन करथि
आउ दी जण पुओ
केते अंडरगॉन केते
रहलेनी 17
already period undergone how much
period 1 month custody from 2017 from the date of arrest
हां
2017 17 ରୁ ରହିଲେଣି
आगुर बेल रिजेक्ट हेती मेरिट रे
फाइलिंग हेतिले जाइन एटा जेसीआर रे थिला 32/21 बेल जाइन
are the learned counsel for the petitioner learned counsel for the state as per the order dated 21/4/2025 the learned counsel for the state has produced the report of the IAC Hon'Ble police station dated 1/5/2025 grounds have been taken in this interim application for interim bill that the mother of the petitioner is old and bedridden and she was admitted to SC Medical College and she needs for higher treatment in the medical.
Minor siblings.
The land council for the state in the report it is mentioned that the petitioner has got 3 sons out of which one is in judicial custody and out of the 2 one is minor and she had also undergone treatment in district headquarters hospital on good. And when the police official visited the house of the petitioner, he found that his mother was sleeping on a charpoy and he complained of joint pains on her body. Stop. The report is taken on record considering the submission made by the land council for the respective party and the factum of detention of the petitioner in judicial custody. केबेठु रहलेनी कहउछन्ती
14/4/2017
फाइनल फॉर्म बाहर कर ट्रायल कोर्ट रे बेल नथिले
ना
Offense is under section 376 here. 376 and IT Act. The offense is under section 341, 342, 323, 506, 395, 354, 354B, 354C, 376D, 292A, read with 66 of the IT Act.
No. He was found guilty under what offense?
He was found guilty under all these offenses.
What 376D is like
The victim was only of 18 years.
What about the other accused persons?
Accused were in custody. I'm not aware. That's because the petitioner was in custody since
The connected
2017.
CRLs are
What about the other accused persons?
the connected CRLs are 799 of 19. CRLA 18.
Are they on bail? Are they on bail?
I'll just check.
Yes. Verify.
You move the application on merit on this ground.
For a period of 1 month, maybe religion.
In view of the report furnished, we are not inclined to grant interim bail to the petitioner. Stands rejected. Yes. Stay relation of fine allowed. Next.
Item 5.
Lordship, my lord, the judgment to appeal is filed by them. One is in criminal of 7
पूरा कोर्ट कर इसमें पूरी डॉक्यूमेंट पूरा कोर्ट कर yes honorable
Arising out of same judgment, 2 appeal has been filed in, one is 73 of 2022 and 7442 of 17.
Same.
How you filed the 2 appeals, Mr. Sahu?
Transfer of the clerkship.
आपण पर आगुटा फाइल करथिले चित्तरंजन साहू एटा भी चित्तरंजन तो कोटा विथड्रॉ करिवे फोन गोटा नॉट प्रेस करियो पड़ो कोटा करिवे आपण दीटार पावर अछि तो मुसे इतमे पछो
पावर ता सब अछि 22 रे अछि पावर
22 रे पावर अछि अब एटा केमति आसिला आपण ना जो से एरबर लखाई चित्तरंजन साहू बोली
विश्वजीत
नायक एंड चित्तरंजन साहू लिखाई जी
कल सर 734 टा नोट प्रेस कर
लिखो दीरा फास्ट लिखी दो CRLA number 742 of 2017 the Mr. Sahu Land Council for the appellant says that since the appellant has filed another criminal appeal that is CRLA number 734 of 2022. He does not want to press this criminal appeal.
So,
see, one position theater for position
2017 failure chair.
delay नहीं
By conviction, 2017 file is done.
नहीं इधर delay फिले बोलते कौन नहीं ये तो देखिए 742 टा 734 टा
734 delay condom.
delay condom नहीं से इतने not अल्लाह so not press करी dispose of कर दें अल्लाह yes ये विश्व रंजन त्रिपाठी को ना अपन तो अपियर करें हो
Your Lordship, I am appearing on this
लेखंतु इटा फास्टर लेखंतु CRL number 734 of 2022. Prisoner's petition has been received for engagement of Mr. Chittaranjan Sahu in place of Advocate Vishwajit Ranjan Tripathi. The Mr. Sahu has already filed Wakalatnama. The Wakalatnama is taken, accepted, and prayer is allowed. The name of Mr. Vishwajit Ranjan Tripathi shall not be reflected in the cause list henceforth. This is CRL number 734. Yes, next.
Paper book बन जाइतिला paper book नहीं चलते
पेपर भी
এইটা রই সেকেন্ডটা রই
সেকেন্ডটা রই
যেটা নট প্রেস হলো সেটা রই
Item 6.
Yes, Mr. Mahanti.
Appellant is convicted under section 302 and court is committed.
You have not supplied the evidence copy. Give the today the Land and Council for the appellant supplied the deposition copy of the witnesses to the Land and Council for the state in court today, who seek some time to go through the assemblies this matter. They can do proposal. Yes.
Item 7.
May I please ask him that? This matter, last time, Lord, get to custody certificate and antecedent. Item 1. Last item. There is also one and
Years, 2 months.
The one antecedent matter, please take note, 311 dated.
What is the offense here?
294, 516 by 34 edition.
Since when you are in custody?
for 27/3/2014.
You are facing the first item.
Yes, item, first item.
CRLA 1042.
Yes, sir.
2024.
4 years, 3 months, 16 days in custody.
So it's a case of direct evidence or circumstantial evidence?
Direct eyewitness. Direct.
So who are the eyewitnesses to the offense?
Eyewitness, sir, my lord. PW 6, 11, 12, 13, 14, 20.
PW 6,
11, 12.
Just a minute. 11, 12,
13,
13,
14, 20.
14 and
20, my lord.
20. What is the deceased?
Name Arjun Raut, my lord. Arjun Kumar Naik.
Raut,
Naik. Arjun Kumar Raut.
Date of occurrence?
Date of occurrence, my lord, 18/4/2014.
And come to one of the eyewitness PW 6. So
8/6.
6 Padandu.
The relevant so far the appellant is concerned below to page 87. Vanchan was assaulted by means of bamboo. 87 below, first line.
ଆପଣ ତ କହିଲା ମୂଳରୁ ପଢିବେ ମଝିରୁ ଆମେ
I know the Lord, I know the informant of this case. I know the deceased. I know the accused along with other co-accused persons of the spilled up case.
Split up case.
Yes. While I, along with Arjun Rao,
Babaji Bari, and son of Arjun Rao were going towards our house at about 8 p.m. on 18/4/2014. The accused Bhagirathi Bari, his two sons Manoj and Vibhuti Panchanan Das present appellant, and others attacked Arjun Rao. The accused Bhagirathi Bari assaulted the victim Arjun Rao by means of iron rod. His two sons, namely Manoj and Vibhuti, assaulted Arjun Rao by means of sword. Sukanta Barik assaulted by means of Bhujali. Then Panchanan Das assaulted by means of a bamboo stick. Ajay Jana and Amay Jana, Lilarani Bari and Vidulata inflicted bricks blow on the victim. Bhagirathi had assaulted the victim Ravindra Jana by means of an iron rod. The accused persons also assaulted the victim Babaji Bari. They also assaulted Vincent Rao and Rakesh Rao when they tried to intervene to save the victim. The victims were shifted to Paul Medical and thereafter Arjun Rao and others were shifted to Kotak Medical, but on the way Arjun Rao succumbed to the injuries. Then paragraph 2, on 19/4/2014, at about 9 a.m. in the morning, the IO has seized weapon of offense, that is bloodstain, iron rod, bloodstain, Pujali, and etc. in my presence and prepared seizure list, wherein I have signed.
So you have assaulted by means of a bamboo stick.
Bamboo stick.
And 11 and 12, both of them also said the same thing.
Assaulted.
You assaulted by bamboo.
So who is the doctor conducted PM?
Doctor Mirat PW 9.
9.
Doctor Mirat PW 9. 9. Found 3 injury. My read me 91.
1, 2, 5 injuries.
91.
Lacerated wound is the first one, skull.
First.
But the second hala intracranial hemorrhage, chhad diyantu.
One laceration.
Lacerated wound, compound fracture, left humerus, dui. Lacerated wound, size left leg. So the tinta external injury.
The first one may be attributable to you.
Blood, that's the omnibus allegation because the blood, PW6 says the.
नहीं आपण ठेंगारे मुंडरे मारचे
PW6
मुंडरे मारिया with final. Anybody has stated that he already had?
I had 11, 12, the same.
11, 12.
11, 12.
PW12 man.
Assaulted by means of ठेंगारे.
So anybody else has assaulted the deceased on the head as per the eyewitness statement? Because they are using the iron rod also.
Yes, yes, Milord. I beg your lordship's pardon. PW6 says, Milord, Bhagirathi, who was holding iron, he assaulted on the victim. I mean, Arjun, this is.
ଆପଣ ପଚରା ହଉଛି ଯେ ଅନ୍ୟ କୌଣସି ସାକ୍ଷୀ କହିଛନ୍ତି କି ଅନ୍ୟ କେହି accused ମୁଣ୍ଡକୁ ମାରିଲେ ବୋଲି?
PW12 only says that head injury. You have given a head injury. 11 doesn't say. 11 and 6 doesn't say that head
12
injury.
says that.
12 says that head.
12. PW12 minutes.
12 says the head.
In the head. 12 with the son and in.
And
my father fell down.
Yes.
On the
that is the injury which caused the intracranial hemorrhage, and according to the doctor also, the cause of death was due to shock and hemorrhage, injury to the vital organ like brain. So, ମୁଣ୍ଡକୁ ମାରିଛନ୍ତି ଅନ୍ୟମାନେ ଯଦିଓ ମାରିଛନ୍ତି ଆପଣଙ୍କ ନାଁରେ ସ୍ପେସିଫିକ ରହୁଛି ମୁଣ୍ଡକୁ ମାରିଛନ୍ତି
PW6 କହୁଛି ଯେ ଯୋଉ iron rod ଯେହେତୁ ବାଡେଇଛି, so there is no other injury except
iron rod ଅଛି ପୁରା ଅନ୍ୟ ଇଞ୍ଜୁରି ଗୁଡାକ ଅଛି ତା ଦେହରେ ଲେଫ୍ଟ ହ୍ୟୁମେରସ୍ ଅଛି ତାପରେ ଲେଫ୍ଟ ଟିବିଆ ଫିବୁଲା ଅଛି ସେଗୁଡାକ ହେଇଥିବ ଯୋଉ ଇଞ୍ଜୁରିଟା କଜ ଅଫ ଡେଥ୍ that is attributed to you.
That is on head.
ଆଉ ଗୋଟେ କଣ ଇଞ୍ଜୁରି କ୍ରିମିନାଲ କେସ୍ ଗୋଟେ ଅଛି 216
No, but the assaulted Vikari Barik assaulted by means of iron rod on my right hand. The iron rod injury is right hand, and the head injury is only by Tenga. ये अपना देखिए 11 if you see fell down. Accused Panchanan Das Guji assaulted by means of Tenga, I intervened, the accused found so assaulted by means of iron rod on my right side. This
on my money, it's a PW.
yeah. He fell down from so better also. Like the injuries also. Accused persons were trying to shift to the zone. Once I'm saying to people also. So rapid by means of sword, not fell down the ground. So,
What is the
18-4.
ଆପଣ ଧରା ପଡିଲେ 27/3/2015 ତାପରେ ବେଲରେ ବୋଧେ ଟ୍ରାଏଲରେ କୋର୍ଟରେ ବେଲରେ ଥିଲେ 2016ରୁ ବେଲରେ ଥିଲେ ତାପରେ 15/12/2028ରେ ପୁଣି 18ରେ ପଶିଲେ 6/4/2021 convict 4 ବର୍ଷ 2 ମାସ 7 ଦିନ What do you say, Mr. State Counsel?
Manner evidence of PW 12. The category of stated that the assaulted by means of Chenga.
The Learning Council for the state has produced the written instruction received from IAC all police stations, which indicate that the petitioner has got one criminal antecedent and is also custody certificate, which have taken on record. Let the Learning Council for the appellant obtain instruction about the status of the case which was instituted against him in all police station put up this matter after summer vacation.
So on behalf of Mr. Hon'Ble, my lord, after custody certificate and the antecedent will call for me. To 11 years in custody from the date of arresting in custody.
The directed matter hauchi CRLA number 221 of 2024.
Bhagirathi Barik.
Mr. Robert Learned Counsel appearing for the appellant submit that he has instruction that the appellant is in judicial custody for
11 years.
11 years. Let the Learned Counsel for the state produce the custody certificate as well as obtain instruction regarding the criminal antecedent, if any, against the appellant put up this matter after summer vacation with CRLA number 1042 of 2024. Yes.
Item 9.
Item 9, may I please, my lord? I am appearing on VC, my lord. Item number 9, my lord.
Yes, RV.
Yes, my lord. This is a bail application arising out of the criminal appeal. The petitioner herein was convicted for offense under section 302 and 201.
Have you received the deposition copies? You are for whom? So 302 case. And you are in custody since when?
My lord, I am in custody at the time of I was in custody from 9/2/2020 to 10/11/2022 to 2 years 9 months, my lord, during the course of trial. And after the date of judgment, that is from 13/9/2024 to till date, that is 1/5/2025.
So during trial, you are not released on bail.
I was released on bail, my lord. I was released on bail on 10/11/2022 by the order of this honorable court, my lord.
Totally custody period you tell.
Total custody. Yes, my lord. Total custody period is 3 years, 4 months, and 18 days as of today.
Okay. What is the name of the deceased?
Deceased is Kailash Das Pradhan, my lord.
Kailash Das Pradhan. What is the date of occurrence?
Date of occurrence is 9/1/2020. It is a case of accident, my lord, which was given color of murder due to political rivalry.
Eyewitnesses are there?
No eyewitness, my lord.
No eyewitness.
No eyewitness. What had happened?
So what are the circumstantial evidence against you?
Yes, my lord. What had happened is on 9/1/2020, the FIR was lodged by PW3, the father of the deceased, Lingras Pradhan, against unknown person, which was registered under section 279-304A, my lord. And what had happened is, in the meantime, it was the case of the prosecution that PW7, that is Manas Pradhan, who is brother of the deceased and son of PW4, overheard the matter that the present petitioner is confessing his guilt to 3 persons. And he disclosed the matter to the family members, and PW3, PW4, the other brother, he gave a report in writing on 11/1/2020, which was seized. And when the charge sheet was submitted, it was converted to 302. This is the whole brief of the brief fact of the matter, my lord.
No, it's all right. That is how the case. Now you tell us that what are the circumstances against you?
Yes, my
Is
lord.
there any extrajudicial confession?
Extrajudicial confession, that was the case of the prosecution that the present
Before whom? Before whom?
for 3 persons, that is one Govinda Biswal, who is PW1,
PW1.
Valmiki, who is PW2, and another Ganapati Pradhan, who was a charge sheet witness but not examined by the prosecution.
Achha. Let us see PW1 what you have stated.
Come to PW1.
My lord. PW1 is 118 of the paper book, my lord.
Yeah.
May I be permitted, my lord?
Yes, yes.
I know the informant, who is my brother-in-law. I know the deceased Kalidas Pradhan, who is my nephew. I know the accused persons who are standing inside the dock. Kalidas died 2 years back. I heard from the villagers that Kalidas Pradhan died due to accident. I was present at the time of inquest made by the police at DHH Parlakhamundi, and I put my signature in the inquest report. P1 is the said report with objection, and P1 by my signature thereon. On 11/1/2020, Ganapati Pradhan told me that Bhaskar Biswal, the present petitioner, was calling me. Accordingly, I had been to the house of Bhaskar Biswal and found Bhaskar Biswal along with Balmikeshwar Swainsaw and Ganapati Pradhan present there. I asked Bhaskar regarding his calling to me, and he replied that he has committed murder of Kalidas Pradhan and asked me to subside the matter. Thereafter, one Manas Pradhan arrived there, and after his arrival, we all returned back from the house of Bhaskar Biswal. On 12/1/2020, a village meeting was held in our village regarding murder of the deceased Kalidas, and in the said meeting, Bhaskar confessed his guilt, and any punishment may be awarded to me. The minutes of the meeting was reduced into writing, and I put also my signature there. P2 is the minutes of the meeting with objection, and P2 by 1 is my signature thereon. Bhaskar Biswal also put his signature thereon. Now the cross-examination, para 4. My street is Biswal Sai of village Jajpur. I have been staying there since 2011. The house of Bhaskar Biswal is 200 meters away from my house. There are houses on both the sides of the PWD road of our village, which runs from...
PW2 did not support the prosecution case.
That's right. I am grateful, my lord. That's right.
What else is there apart from extrajudicial confession?
Extrajudicial confession, apart from that, nothing is there, my lord. And
last scene?
No last scene, my lord.
Motive?
No motive also, my lord. It was purely political rivalry, my lord. That is what the case...
My lord.
Schedule 6, my lord. 152, my lord.
Schedule 6.
My lord, 5, 6, and 7, all witnesses, my lord, categorical have stated that intentionally that the accused killed the deceased, and it later went a color that they are dashed by the killed the deceased by. I will also PW5, who is the independent.
Have you seen it? What is the basis of his deposition?
All India radio कहला ना दूरदर्शन ने ना केम जानला पचार
जानिला इन द सेंस मिला
कहला आपसे
ना से निजे कॉन्फेस से निजे कॉन्फेस करूची विलेज मीटिंग रे आपने आई हैव
तो पचार स्टेशन छोड़ा और कौन अछि
अच्छी बात लीडिंग टू डिस्कवरी अच्छी बात
कौन लीडिंग टू डिस्कवरी
अच्छी जो थे मारिला से जो गाड़ी रे जाते ट्रैक्टर दैट हैज बीन लीडिंग टू डिस्कवरी दैट को जाता है सीज मिला
leading to discovery of what?
जो ट्रैक्टर गाड़ी जो से चढ़े की मारी थी डेड बॉडी टाको नहीं किया
और चढ़े की मारी माने की गोली मारी
तो निजे कन्फेस कर विलेज मीटिंग रे
Therefore, the end of the day, except confession, there is nothing.
There is nothing.
There is nothing.
Only the extrajudicial
कंफेस leading to discovery part टाइम जो गाड़ी रे मारी तो
Again, you are going to that confession. Except confession, what is there? We are asking.
leading number that leading to discovery रे ते जोथरे माथा डाटा जो रिकॉर्ड अकॉर्डिंग टू स्टेटमेंट मिला ठीक सेति अछि
गाड़ी चढ़े की मारला
हमार इंटेंशनल मार지 काय ना दैट
with the doctor
डॉक्टर पीडब्ल्यू क्यों है पीडब्ल्यू 8 that's way to 161
what he has stated
on 9/1/2020, I was working as my present post at the DHS Pada Committee. On that day, at 1 p.m. on police requisition, I conducted the autopsy over the body deceased Kalidas Pradhan, being identified by the C3 of the Behra and found the following. Body was average build of 5 feet 4 inch length, dark complex rigor.
So the nature of death is accidental. He has stated
that the cause of death is homicidal shock and mode of death is due to the injury of brain.
So who जगह dead body मिलला
डेड बॉडी पीडब्ल्यू 5 मिनट सम से नहीं कि निजे मारी के आने के देखि छिला दे एक्सीडेंट हेला मगर दैट पीडब्ल्यू
who जगह रे dead body टा पड़ी थिला who has seen that dead body you see if it is an accident matter is different but if it is you say that it's a murder by dashing the tractor voluntarily so there must be some kind of thing in the at the spot. So who has said about that?
Anything? Anything? Any evidence to that?
रास्तारे जाउची ताकू इंटेंशनली मने करंतु मारिवो ते बाजीकिन घुंची वाला पुणी आउथरे बैक करिकिन मारिवो सेमति किछि सिम्पटम्स स्पॉट रे हला ना गोटे थरो डैश कर दी पड़ेला तो की नाही ती एविडेंस नांती वेदर that effect
नाइट रे घटे घटना intentionally because it's the
initially the case was under 279/304 that is the FIR.
Yes,
come to PW9. PW9 postmortem was conducted. Thereafter, it was the body was taken in and cremated.
That has been the postmortem report.
And come to 9. Come to 9.
PW9. PW9 the paragraph 2 melody reading. The deceased died near about 2 years and 8 months back. Hearing death of deceased, I had been to DHS Parla Committee. The informant lodged written report of accidental death of the deceased at the instance of accused Bhaskar. Accused Vijay Malla, Bhaskar or Parla Committee. After the postmortem examination was conducted at hospital and thereafter the dead body of the deceased was shifted to burial ground in the ambulance and was cremated hastily by the accused Bhaskar. Intentional Bhaskar which created doubt in the mind of the village people. So a meeting was convened.
He was taken to hospital. Postmortem was conducted. Thereafter the burial has taken place.
Everything
maybe he is a villager, he might be there. That's not.
So what
is the evidence for that part, killing part?
I want to prove my lord also satisfied. Intention to kill my lord, intentionally he has dashed by dashing the tractor.
What is the motive?
Motive, my lord, because
motive must be there. So motive is kill. What is the motive to kill?
Yeah, the evidence also is there that the accused is the Malik of a Natta Sangha Miller. Wrote a Natta Sangha Miller, Nacho. That the one of the lady was there, Miller. The accused was law.
Evidence अच्छी ना कि
that PW5 all of my witnesses are prosecuting supporting the prosecution case. That intention that the accused killing the deceased man. Thereafter color the accident. So निजे dead body धर के आसिला निजे तत्तर वाले कला पड़ी दे सब निजे चेट मार देला निजे एफआईआर दे देला कला 279 everything has been done by the accused. से जो आपण कहतो सेटा म आउथरे पढि दउ से सेंटर PW9 मिलर उतर परमिशन मिलर बट आउट डायरेक्ट पार्ट रह गेला से. So a meeting was convened in the village
and accused Bhaskar was called to the said meeting where he confessed to have killed the deceased Kalidasa Pradhan with the assistance of his associate. The minutes of the village meeting was reduced in writing. Therein, I have put my signature. It is my signature, my lord. Police also seized the CDR, जोटा कहीं सेटा record करा जी IIC also my lord with the PW11 seized the CDR report जोटा कि record करा था voice टा से मारी ची बोली जोटा सेटा मतलब करा है my lord. And others my lord, the PW5 is an independent witness. It will also have to kind of grant the PW5 and PW6 who are the independent witnesses, my lord, that they have what they have taken, my lord. Permitted to the read, my lord, page 142 page of paper book. On 9/2/2020, myself and Lakshmi Kanta Pradhan had come to Parlakamandi for our personal work, and we heard that the police apprehended accused Bhaskar Biswal. Having heard this, we went near to the police station of Parlakamandi and IIC called us to remain as witness in the case. We went inside the PS, wherein our presence Biswal stated that Tiki Pradhan and an artist had a love relation with accused Kalidas Pradhan. Like that I'm saying before Lordship. And subsequently, there are misunderstandings between both Tiki and Kalidas, for which deceased Kalidas made their conversation made third mobile phone viral show. Tiki Pradhan told the matter to Bhaskar Biswal against Kalidas Pradhan to prevent him not to viral such conversation. But Kalidasa did not respond to Bhaskar Biswala and continued his above act. So Bhaskar Biswala apprehended that the artist Tiki would not participate in the Nacho party, for which he Bhaskar
Learned counsel for the Mr. What is your good name, Mr. Counsel? Appearing through
Dipankar Panigrahi.
Who would have your good name?
Dipankar Pandit.
Who would have your good name?
Jaipur.
Are Mr. Dipankar Panigrahi, Land Counsel appearing through virtual High Court, Jaipur, Koraput, and Counsel for the State Counsel for the Informant. The Land Counsel for the appellant petitioner submit that the petitioner was taken into judicial custody on 9/2/2020, and during trial he was granted bail, and after the impugned judgment was passed, he has been taken to judicial custody, and he has remained in custody for 3 years and 4 months. Land Counsel further says that initially the FIR was registered under section 279 and 304A of the Indian Penal Code against unknown person by the father of the deceased, Kalidas Pradhan, and there are no eyewitnesses to the occurrence, and the main circumstance available against the petitioner is the extrajudicial confession in a village meeting. He further submits that the prosecution has also not proved clinch motive on the part of the petitioner to kill the deceased, and therefore there are good chances of success in the appeal, and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned Counsel for the state opposed the prayer for bail. Learned Counsel for the informant placed the evidence of PW1 and PW2. It appears that PW2 has not supported the prosecution case, and PW1 has stated about the confession made by the petitioner in a village meeting. He also placed the evidence of PW5 and submits that the materials available on record indicates that after the postmortem was conducted, the dead body was disposed of hurriedly at the instance of the appellant. Considering the submission made by the London Council for the respective parties, absence of any direct evidence, nature of circumstantial evidence on record, the fact that the petitioner was on bail during trial, absence of any chance of early hearing of the in the near future, we are inclined to release the petitioner on bail subject to condition that he shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail. Yes, next.
Deeply obliged, my lord. Grateful.
Item 10.
Yes, Vishwa, Ms. Vishwa.
Offense under 302, as we see, there is no direct witness. The appellant is in custody since 19/12/2019. Last occasion on 21 April 2025, your lordship directed the state council to take instruction about the whereabout
Of the child.
of the child of the accused appellant.
Yes, what is your instruction?
Yes, I've given this.
The petitioner is a lady. And he is aged about 25. Huh?
No.
25 ବର୍ଷ ତାକୁ ହେଇଛି ଆପଣ କେମିତି ଲେଖିଛନ୍ତି that her only son Ravi Mandal, who is aged about 24 years, is now residing with his wife. ଯାହା ବୟସ ହଉଛି 25 ବର୍ଷ appellant ର, ତାର ଗୋଟେ ପୁଅ କେମିତି ହବ 24 ବର୍ଷର?
ସେ ତାର ସେ କହିଲେ ଆ ପାଖରେ ରହୁଥିଲା she was married to some other person.
ସୀତା ହେମ୍ବ୍ରମର ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ଅନୁଯାୟୀ she is aged about 25 years. ନୁହେଁ କି? ଦେଖନ୍ତୁ ଜଜମେଣ୍ଟରେ ଦେଖନ୍ତୁ ଏଜ୍ ଲେଖା ହେଇଛି. And your report is that confinement ରେ ଯୋଉ ଅଛି ସେ ଛୁଆ କେହି ତା ପାଖରେ ରହୁନାହାନ୍ତି. ଠିକ ଅଛି. I have the honor to apprise that during course of inquiry it reveals that her only son Ravi Mandal is 24 years, son of Budha Marandi, is now residing with his wife Puja. ମାନେ ଏଇଟା ହେଇଥିବ ସେ ବୁଢା ମରାଣ୍ଡିର ପୁଅ ହେଇଥିବ ଏଇଟା. ହଁ,
because that is the
her only son ମାନେ step mother ହେଇଥିବ ଏଇଟା.
But there is a child out of the relationship. That's what.
କିଛି ଛୁଆ ନାହିଁ.
ତା ଭିତରେ କିଛି
ନାହିଁ.
Paragraph 2 of the judgment that stated that the unfurther prosecution.
No, we were asking you about the whereabout that child born out by this lady.
So some evidence is that the child was born.
Yes.
So we are not asking for se chua kuada gala nearly je taro
Let's see.
On the evidence of PW7, it appears that the petitioner was staying with the deceased डिसीज टा होची तारो जहा पाखे रहुतिला there was physical relationship between the petitioner and the deceased. Out of the said relationship she gave birth to a male child. ये जो छुआरा हमें पचारतलु not that ता स्वामी रो जो first wife रो छुआ बुझ पाले ना but admittedly as it appears that no child is staying with the petitioner in jail
custody
so custody nahi bahar what are the circumstantial evidence against you?
PW 7 and 11 stated that the appellant was staying with the deceased in the rent house and he made a call.
PW? 7 and PW?
PW 7 and 11.
7 and 11. So you and the deceased, they were staying together.
As per the statement of PW 7 and 11.
Then ठीक अछि dead body could मिलला.
In the said house, your lordship.
So how your that person died? You are staying with a person who died and the dead body was found in that very house and it is a case of homicidal death according to the doctor. Who is the doctor? PW3.
Well, he is the doctor.
Job punta ଅଛି ଗୋଟେ ଅଛି ନେକରେ ଆଉ job punta ଚିକରେ ଅଛି
1273
ହଁ ସେ ଉଧର ଗୋଟେ ହଣା ହେଇଛି କଟୁରୀ made up of iron କଣ ଆପଣଙ୍କର 313 statement ର ଇଏ କଣ ରହିଲା ଖାଲି ଜାଣିନି ମିଛ କଥା ये जो कन्फ्रंट है 7 नंबर साक्षीर एविडेंस टा आपको ये आपण आयु सहित रहुथिले अच्छा कौन आपण कहले बड़ा मरांडी मो आगुरु रखिथिला ता ओरसरु मोर गोटे वो अच्छी अच्छा
that's we were done by.
PW7 was staying that so you are staying in the ground floor. मुसलमान को जानी नहीं अच्छा
मुराहिनी की कोई करी
तो मना कर ऐसे
PW 6 and 7 never says about the appellant, presence of appellant. PW 6 is the elder brother of the deceased who lost the FIR and his wife, Buddha Marandi's wife, was also not examined. He was staying with a lady, but his family member does not say anything about that. It's only the outsider. PW 7 and 11 are the outsider.
Petitioner and counsel for the state. Considering the submission made by the land and counsel for the petitioner that the petitioner is in judicial custody since 1912-2019 and she is a lady and there is no direct evidence the case is based on circumstantial evidence and there is no chance of early hearing of the appeal in the near future after going through the written statement, written instruction produced by the land and counsel for the state received from Senior Superintendent Sarkwijal Barikwada as the order dated order order dated 21/4/2025. We are inclined to release the petitioner on bail allowed.
Minus child. Is a minus child.
Yeah.
She has a minus child.
And that she is a minor child. She has a minor child.
Because communicated through register because this is a jail criminal. So
The 20,000 once you recover. And the copy of the order, the communicated to the London trial court by the registered judicial who shall act upon it, you know, since it's a jail criminal appeal. And the London Council for the state shall also send a copy of the order to the concerned jail superintendent. Yes, next.
Item 11.
Item 11, it's no any interim bail application, as his mother was suffering from brain stroke.
What is your instruction?
Just now my friend served the copy.
Acha, 1127 of 2025. There is an application for interim bail on the ground. Who paragraph in that the mother of the petitioner is suffering from serious ailment and she is now bedridden. And our condition is deteriorating day by day. Have you not, why have you not filed any medical documents?
Just now also handed over a.
Acha. So, the London Council also filed the medical document in court in support of. No, you filed with a memo. Please note on. And handed over the copy to the and make it true copy attested. And the London Council for the state shall obtain inspection on the interim application and the authenticity of the medical document which has been handed over to him. True copy attested করন্তু memo সহিত file করুন না সে medical document authenticity দেখুন বাকি instruction নিয়ন্ত্রণ করুন. Put of this matter will be commencing from 12th of May 2025.
Based on my instruction last page also.
ঠিক আছে আসিও রিপোর্ট এখন
আগুন দিয়েখানে তার সাথে ফাইল করতে ভেরিফাই যে আমরা
নেক্সট কোড লক্ষ্য করি আর
Thanking melodies.
অথেন্টিসিটি ডকুমেন্টটা কোডি আর
Document है भुवनेश्वर आदित्य अश्विनी हॉस्पिटल चंद्रशेखरपुर.
ନାଇଁ ଟାଇମ୍ ଲାଗିବ ଏପଟକୁ ଯିବ ସିଆଡ଼େ ଯିବ ଯାଇ ତା ଘର ଦେଖିକି ଆସିବ ଏଠି ସେ ଅଥେଣ୍ଟିସିଟି ଟାଇମ୍ ଲାଗିବ 12/5. ନେକ୍ସଟ
Item 12.
I have not different notification itself. First time this stage.
My lord, in the paper book also C report, so not prohibited.
Don't tell me.
Jail criminal.
C report has been marked as an exhibit.
Forwarding का अच्छी. Forwarding अच्छी. Just a minute.
No, forwarding to no. If the C report, many cases, these are forwarded to the forensic science laboratory for examination and report, but C report not received, no steps are also being taken by either the public prosecutor or by the trial court.
No.
To have from the
Not
that is not there. So you have received the copy of the paper.
Yes.
So Why didn't you receive it earlier? Direct evidence, no circumstantial evidence.
No, direct eyewitness is there.
Is in custody.
The instruction
Bail.
my lord. Last time it is listed.
But there is no bail order here. Status mode put it.
Status table.
Status mode.
The learned counsel for the appellant submits that she has not received the copy of the paperwork. Let a copy of the paperwork be supplied to the learned counsel for the appellant. Trial court record of her. Soft copy of the trial court record in digitization section. Okay. Court record कहीं final phone कहीं हाँ trial court record कहीं ऐठी नहीं कहीं
Trial court नहीं paper उठ खड़े हो गए paper उठ खड़ा
पेपर तो अच्छी है trial court हम record online जिनसे देखिए आपने
नहीं तर
देख अच्छी तो है record is not available, the soft copy of trial court, but it is mentioned that it is in digitization section. So the same be placed on record. Stop. Since its jail criminal appeal is of the year 2010, the learned counsel for the state shall obtain instruction about the status of the appellant and his well-being to also produce the custody certificate.
Lordship, another prayer, Lordship, item 33. সেটা আমি ফার্স্ট টাইম দেখতে এসেছি তাহলে পেপার বুক পাইনি এটা 19 ইয়ার্স হয়ে গেল
ওটাকে ফার্স্ট টাইম লিস্ট ହେଇଛି ଆପଣ ସବୁଥିରେ ମଗେଇ ଦିଅନ୍ତୁ ସେଇ ଟାଇପର ସେ କମନ ଅର୍ଡର କରିଦେଲେ ଗୋଟେ ହଉଛି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ସେଟା ହଉଛି
କାଲି ଗୋଟେ କେସରେ ଅର୍ଡର
କାଲି ହେଇଥିଲା ନା
କାଲି ଅର୍ଡର ହେଇଥିଲା
whether released on premature bail
ସେଇ ଟାଇପର କରିଦେଲ
2009 ଯାଇ ସମସ୍ତ ସବୁ ଏଗୁଡା ତାପର ଗୁଡା ସେମ୍ ଅର୍ଡର କରିଦେବ
ଲର୍ଡସିପ ପେପର ବୁକ୍
ପେପର ବୁକ୍ କୋଉଥିରେ ଆପଣଙ୍କର
ଦିଟାରେ ଦରକାର
ଏଇଟା ତ ଅର୍ଡର ହେଇଗଲା ଆଉ କୋଉଟା ଦରକାର 33 ରେ ପେପର ବୁକ୍ ଦେଇଦେବୁ ତମ ହେଲା
ଆଇଟମ 15 ରେ ରେକର୍ଡ ଇନଫରମେସନ ଦବାର ଅଛି ଏଟା ନାଇଁ ନାଇଁ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଡେଥ୍ ବୋଲି ରିପୋର୍ଟ ଆସିଯାଇଛି ଆଇଟମ 15 date obtained the wherever 12 weeks report has come here date since 2024
right
death ଅଛି 15
ଆଉ କାହିଁ ଆସିଛି ରିପୋର୍ଟ ଆପଣ କୋଉଟା ରିପୋର୍ଟ ଆସିଛି
ଗୋଟେ ସେଟା ଏ ଜାନୁଆରୀ ମାସ ମଗାଇଥିଲା ତେଣୁ ଆସିଛି
ଆଚ୍ଛା ଯୋଉ କେତେ ଗୁଡାକରେ ଲେଖା ହେଇଛି ଦେଖ ଷ୍ଟେଟ ରୁ ପ୍ରଡ୍ୟୁସ ସେଗୁଡାକ ମାନେ ତମର ଆଗରୁ ଅର୍ଡର ହେଇଯାଇଛି ତାପରେ ସେଗୁଡାକରେ ଲେଖିବେ ହି ସିକ୍ସ କମ୍ ଫର୍ଦର ଟାଇମ ହେଲା ଖାଲି ଏଇଟା ଲେଖନ୍ତୁ 15 ନମ୍ବରଟା ଲେଖନ୍ତୁ the as per the order dated so and so the land council for the state has produced the written instruction received from OIC Mopali police station Sambalpur wherein it is mentioned that the appellant expired on 8/10/2024 and the death certificate of the appellant has been annexed to the report. The report is taken on record. The jail criminal appeal is disposed of and stands abated for them. Stands abated and disposed of. Then if anyone wants to challenge any of that term is legal,
Stands evicted public at 2390.
no, it's you. Six appropriation for to continue the appeal or to recall the to revive the appeal. The same shall be placed again for consideration. Yes. Data disclosed of abated provision to be indicated in the section 394 our corresponding roju BNSS the provision which is proposed. Our kutre paishan the report upon
Our report is
नहीं नुआ नहीं 18 नंबर देखो तो आगुर मगा आइतला state to obtain whereabouts and well-being. Then अच्छा आउ गोटे अच्छी देखो 22 नंबर state to obtain instruction regarding तो ये जो मैटर उठा करे 22 नंबर भी ऐसे नहीं
She's inside the custody. She's taking treatment for
नहीं उठा instruction अच्छी दे दियो तो माने आगुर मगा आइतला पुणी अब सेटा रिपीट कौन पे होगा दियो 18 नंबर
alive and residing with his family.
Item number 18 lekhantu, that is JCRLA 43 of 2010. As per the order dated so and so, the Land Council for the state has produced the report of dated 1/5/2025 of the IAC police station, wherein it is mentioned that the appellant is now residing in his native village and managing his livelihood as an ice cream seller. The report is taken on record. Stop non-appears for the appellant. Put up this matter after ensuing summer vacation. Acha.
18, huh?
Non-appears to gatti diyantu. What do you want? Are you ready, matter? Paper book receive karichandi? Padhiyana. Acha, lekhontu. It is stated.
Paper book has also not supplied to.
Acha kona the Land Council for the states, also the Land Council for the appellant submits that they have not received the copy of the paper book. Let the registry supply the paper book to the Land Council for the both the parties. आपनकर जो मानकर पावर अच्छी बीके रगड़ सेमानक भितर कहा कोंतु आसी बुक टा रिसीव करने बे आज मैटर कोर्ट रे अच्छी पेपर बुक अवेलेबल अच्छी हैला और स्टेट काउंसिल को भी दे दियो तो नोटिंग करने जिवे बाकी आउ को थरे पाइछन इंस्ट्रक्शन
Item 22.
22 रे कौन पाइले
He is confined in the jail custody. He is undergoing psychiatric treatment.
अच्छा 22 रे लिखि देबे इंस्ट्रक्शन ये आछि शॉर्ट रेफर लिखि देबे है ना बाकी राजेश त्रिपाठी is not there. अच्छा non appears कर दियंतु for the appellant after ensuing summer vacation. Item number 22. Let's high stop.
Last item also is 192 instruction.
The डेल फेल किसी नहीं ना दे और से जो एज भी नहीं तर से ही चले से होगा
जो ये स्कीम जो अच्छी सी स्कीम रे
स्कीम तो दीटा जो टर्मिनल इलनेस माने instruction as per the order dated 4/2/2025. है ना? Put up this matter after summer vacation. से जो 2005-6-7 एमती आम सीरियली कर फोटो ये करूँ जोड़ाक जेमिति हेले ताकू डेट रे केतोड़ाक बोधे अच्छी 12 तारीख तो रिपोर्ट को जेमिति हेले आनो तो आमे माने जानी नबु जे तार जदि प्रीमैच्योर रिलीज हेइनी एवं कस्टडी अच्छी बा बेल अच्छी आरबीआई अच्छी ताले विल टेक स्टेप्स फॉर फिक्सिंग द डेट ऑफ हियरिंग तो पुराना केस उठेबार उद्देश्य होची से है ना तो ताकि जेमिति हेले रिपोर्ट आनो